Hey, good morning, guys. How is everybody today? Um, it is August 20th. It is 1 o'clock. I did go ahead and start early. I wasn't sure if I was going to be able to make it here at 1 or not, my usual time, because, things happen. Life happens. Real life happens. I ran to the post office. There was a line. It happens. So, with that, I hope everybody is having a wonderful day. Hi, my name's Sheila. In case you're new here, this is the Rubber Ramada Crime Time channel. We're true crime with a bit of rubbery comedy, a little slapstick, y'all know. I like to be a little, add the comedy to the chaos. That's my favorite line, comedy to chaos, because things can get a little out of control, out of hand, and we need to laugh. We can't all sit around and just be depressed every day, all day, and hopefully I can bring a little lightness to your day. So with that, we are on day 5 of Georgia versus Christopher Wolfenbarger, and what I have seen of trial so far this morning is it's a little bumpy with the audio. I've been in other chats. When we get to the audio stuff, I'm going to skip over that because it is horrible audio. I'll play it for a second just so everybody can understand what I'm talking about and how bad the audio really is. And then y'all will understand why I will skip over the audio portion of this and just let the gentleman talk, and then we'll go into the next witness. So with that, let's roll. Of course, a lawn crime has no sound this morning. Hold on just a minute. Let me. Why? I want that beginning part because they were talking about a juror. So I will have to go to Court TV to pull that part. I found it to be quite interesting. Okay, let's see. Let me back it up. Well, maybe. Okay, here we go. I got it pulled up. Sorry, guys. Sorry about that. This is just too much. There's a lot right now. Okay, I got it. Okay, because I wanted y'all to be able to hear this.
Okay, we're going to go on the record. And today is the 20th of August in the trial of the state of Georgia versus Christopher Wolfenbarger, case number 24SC004201. I'll note for the record that Mr. Wolfenbarger is present here in the courtroom along with his counsel, and that counsel for the state is also present. Mr. Samuel.
When I left court yesterday, I think the prosecutors are still in here. I was walking past, towards the elevator, and one of the jurors was in the sitting area.
Yes, sir.
And he looked like he was, like really, really ill. He was just kind of hunched over, and I have no medical training. Plus, I was debating my role as a good Samaritan, and my job as a lawyer. Fortunately, I saw there was a deputy at the end of the hall,
Yes,
and I went to the deputy and I said, "Someone's got to do. I can't talk to this person." So the deputy went back and talked to him. I was not within hearing distance and stayed out of sight. I gather he was in a great deal of pain from a back injury and was taking medication. I'm not quite sure what happened after that. I mean, the deputy eventually left, and I didn't. There was nothing for me to do. I mean, I wasn't going to sit there with the juror, obviously. I just bring it to your attention that the juror was apparently in so much pain he was taking medication. That concerns me if he's sitting here in the courtroom.
Well, thank you. Do you know which juror it was by number?
Oh, good Lord. They're going to call the juror out. Hopefully not too bad. But this lawyer, or this defense attorney, Mr. Tattletale over here, he was taking medication in the hallway. Sir, come on. It's okay. We all have to take medication every now and again. With that reminder, it's medication time in my house. I will take mine.
certainly not by number. It was a black man, not the one who does dialysis.
So not 43.
And not the taller man who, I'm sorry, I don't.
Okay. I mean, and the main reason I ask is that I'm surprised that you would have such an encounter and that
Girl, don't be pushing buttons. Look what happens when I'm
having an issue, and I've not heard any such communication from that juror. So
I was trying to type. I don't have feedback. Hubby's still home, so I have to mute when between talking. So that's what it. No feedback, love. It's I think it's just Mr. Loud TV in my background for the next hour.
if they are struggling with that, it's unfortunate, but it seems as if they don't feel the need to bring it to my attention.
I just felt the need for me to bring it to your attention, but
I understand.
I remember, obviously I see the jury. I've never seen him in the jury box appear under any distress. So,
okay. Well, what I'll do for now, rather than, formally inquire, put anybody on the spot, is just, if it's okay with y'all, is just have Miss Johnson check in. She's my JA who takes care of the jurors, and make sure everybody's comfortable. And if you're not comfortable, you're having issues paying attention, you need to let me know so I can bring it to the judge's attention and let you know if I get any report from that. Okay.
I'll just make a mental note of where he's sitting.
And then maybe you can tell me, we can identify him further so we'll at least know which juror it is. Okay.
I think you're right. I think because Mr. McDermott brought that to my attention.
Mm-hmm.
And as I was going out of the courtroom, I saw that juror. I believe it's a juror who may work for Delta, if I'm not mistaken, the shorter black man. I think yesterday he was sitting in the second
or third from the end.
from the back row. I think he had on green yesterday. And I saw him leaving as I was going towards the right, towards the restroom. It looked like he was getting up from that area and leaving the courthouse.
Hang on just 1 second.
Didn't mention back work on disability.
Now, juror's not having a nap. Juror was taking medication, and he gonna rat out to the judge. Okay, wait, look. Okay.
Wait, Miss.
No, he's not leaving. He's not leaving. And this is the problem with the damn audio. They're having problems with this audio that they're trying to play. They bring the jury in.
Come on up, sir. When you reach the witness stand, before you have a seat, if you'll turn and face the deputy.
Okay, see, and now, okay, on this channel I can't hear, so I have to switch back over here because I don't know these stupid channels. Let's see, we're going to switch back over here. We're going to share this tab instead. We're going to go back to Law & Crime. I've been trying this morning to make this work with you guys. I'm not kidding. I have worked my little tail off and watched other channels and try to figure out how to make this thing work.
Before you have a seat, if you'll turn and face the deputy and raise your right hand, he'll swear you in.
So sound is down for just a second and it will come back up.
Please state the security full name for the court.
First name Michael, Michael. Last name Sprinkle, Sprinkel.
And good afternoon, Mrs. Sprinkle. How are you currently employed?
I'm employed as a deputy that RCA.
And what he does is
You
video,
extracted from the September 12, 2001 video.
Yes, it hadn't been altered or manipulated in any way.
He takes a
And then was there a
VCR tape
redacted version?
and he talks about how he put it in his VCR, his lovely VCR.
We can tell somebody's talking, but you can't really tell what they're saying.
And then
I don't
we have
know if the
problems
fact that
with
that
this
speaker was
stupid
facing the
tape.
jury made it more.
They go on
Jurors
and
can
on.
hear the audio from that.
Hours, and they are people. It's an hour, and they trick us. We didn't do anything. I don't know what's going on. I don't know, and I'm very frustrated. So even skipping over this whole juror, I don't know what's wrong with the sound. Let me see if I can get it over here on this one. Okay, here we go. This one says, I'm gonna put still this whole time, we can't hear anything. You can get onto a new witness. No, you can't hear any. Yeah, but there's nothing. Hang on. Okay, see, okay, I just had my husband mute the TV. See, look, you cannot hear. I don't know what's going on with the sound.
Two coalitions, a statewide coalition.
And just tell the jury about
This one's a little bit.
So my job duties as a consultant is I'm a researcher, practitioner, and also a trainer for intimate partner violence and gender-based violence. I also do sexual violence and child abuse. I do trainings, I do presentations, panels, whatever the community needs me to do. And I also do expert testimonies.
And how long have you had your consulting firm?
It's been open since January of 2023.
And if you can tell the jurors, how long have you been in the space of working in intimate partner violence?
I started working in the intimate partner violence movement in 2012.
And just tell the jury about your education, your job training in intimate partner violence.
So I started working in the intimate partner violence movement in 2012 at Harbor House of Central Florida. That is a local domestic violence center in Orlando, Florida. And then I continued throughout I continued to the Florida Coalition Against Domestic Violence, and then I moved to the Georgia Coalition Against Domestic Violence, and that's how I got to Georgia. My education background, I have a bachelor's of science and legal studies from the University of Central Florida. I have a master's of social work from the University of Central Florida, which is a clinical program. I also am currently finishing up my PhD at Clark Atlanta University in the social work program, policy and organizational leadership.
I'm going to do something
from the Georgia Coalition Against Domestic.
I'm going to do something I never do, and I don't even know what else to do. No, it's not off. Give me just a second. Let me turn it off. Okay, go ahead, babe. It's off. Go ahead. Yeah, I have the camera off, babe. It's okay. So I don't know what to do about the sound. The horrible thing that I want to do is, because Recovery Addict has good sound, let this witness play through his sound until I can figure out the sound issue. I hate to use another streamer's stream.
Panels, whatever the community needs me to do, and I also do expert testimonies.
And how long have you had your consulting firm?
It's been open since January of 2023.
And if you can tell the jurors, how long have you been in the space of working in intimate partner violence?
I started working in the intimate partner violence movement in 2012.
And just tell the jury about your education, your job training in intimate partner violence.
So I started working in the intimate partner violence movement in 2012 at Harbor House of Central Florida. That is a local domestic violence center in Orlando, Florida. And then I continued throughout I continued to the Florida Coalition Against Domestic Violence. And then I moved to the Georgia. Okay, I'm not comfortable doing that, guys. I'm not comfortable doing that. I'm not comfortable taking that from RA. I don't. I'm going to try to fix the sound a little bit better, but that's all I can do. I'm not comfortable doing that.
In the state of Georgia as an expert in domestic violence?
Yes.
How many times?
If you would like to see a better stream.
So Florida has been 27. I'm about to do the math. I want to say around 47, 48 times in the state of Georgia.
Your Honor, at this time, the state legislature tender Ms. Rosa James as an expert in domestic violence relationships, and domestic violence relationship dynamics.
Mr. Samuel?
I don't know what to do.
We'll reserve right here for cross-examination.
Okay. So, ladies and gentlemen, Mr. Samuel, come here, please. Miss Hilton, y'all both come here.
Would you like me to step out?
No, you're fine. Thank you. The state is offering, excuse me, I'm sorry. The state is offering the testimony of Ms. James as an expert witness. And so at this moment, I'm going to just instruct you generally that people who testify as experts are testifying because the proponent of the evidence believes that they have specialized experience, training, knowledge in a particular field that's not common knowledge or known to the average citizen. And the law permits a person who is testifying as an expert witness to give their opinions based on that training and experience. You are not required to accept the testimony of any witnesses, expert or otherwise, and testimony of an expert like that of all witnesses is to be given only such weight and credit as you think it is properly entitled to receive. Thank you. Please go ahead, Ms. Hilton.
Thank you, Your Honor. Ms. James, can you please define domestic violence for the jury?
Yes, the definition of domestic violence is a pattern of coercive behaviors to gain and maintain control over your partner.
And based on just your training and knowledge, how familiar is the public with the issue of intimate partner and domestic violence?
So the public is familiar with the concept of intimate partner violence, specifically the physical aspect, but the science behind that, the science behind domestic violence, the public typically isn't well versed about what's under the iceberg, typically just above, which is physical violence or any type of sexual violence.
And over the course of the years, has there been some type of increased knowledge with the public as it relates to people watching kind of like true crime television?
Yes, it's specifically, the boom of the internet is information that's there, and through the true crime or any type of documentary, yes, the public can access that information.
However, in your experience, has the knowledge that comes from, say, internet or from podcasts or true crimes, is that the full knowledge or understanding of the science of domestic violence?
No, it is not.
Based on your work in the field, what are some common misconceptions regarding domestic violence?
So the biggest misconception, if the survivor leaves the relationship, the abuse will stop. And that is not true. The data shows that's the most lethal time in the relationship. That is when the survivor is under the most danger and most likely to be killed. So that is a misconception. The abuse does not stop just because someone leaves the relationship.
And based on kind of some of the trainings that you've done in your experience, what are some of the beliefs about why an individual may remain in an abusive relationship?
So there's a host of concepts and theories and perspectives of why someone would remain in an abusive relationship. The biggest factor is power and control. This person has exerted power and control, and the victim or the survivor feels as if they have to stay and remain in this relationship. Also, there's a component of fear and protection, protection of children, protection of self, protection of family members. It's many different dynamics of domestic violence why someone would remain in that cycle of abuse.
And are there any research, is there any research about how long it usually takes a survivor to leave an abusive relationship?
Yes, the research state on average, it takes 7 times to fully leave a relationship that is abusive.
Now, are you familiar with the term or the concept of the cycle of violence?
Yes.
How are you familiar with the cycle of violence?
So the cycle of violence is a cycle that shows how a survivor would remain inside or trapped inside of a abusive relationship with their partner.
And is there a demonstrative that you sometimes use in order to explain the cycle of violence, or is it also called the cycle of abuse?
Yes.
You have permission to approach?
Go ahead.
I'm going to show you what's been marked as Stacy's exhibit number 79. Do you recognize Stacy's exhibit 79?
Yes.
Y'all, I'm gonna have a meltdown. I'm gonna have a freaking meltdown. Do y'all know what? You see these headphones? I don't know why, but it's only in one ear. And I've had it in the wrong damn ear this whole time. So that's why I couldn't hear. It's not the court. It's me. Y'all, this is, okay, comedy in the chaos, okay? I just realized when I picked up my other headphone. I'm over here trying to adjust this. Y'all, okay, I stop. I'm done. I'm backing up. I feel so bad. I feel so stupid. Y'all, oh my God, y'all. I'm over here boosting sound and shit. Y'all, I lost.
How do you recognize Stacy's exhibit number 7?
Because now it's screaming in my ear. Now I have to adjust the sound to turn it down because I had it turned up to 60 on this. I had it boosted to 300 on this. Y'all, it was me this whole time. I am so sorry. I apologize if I've been blowing your ears out.
79.
This is a cycle of abuse. It's an evidence-based tool we use in our practice to show how survivors stay in relationships.
And will this demonstrative assist you and explain the cycle of abuse to your?
Yes.
You're at this time to state like the Stacy's exhibit 79.
Mr. Samuel,
No objection.
79 is admitted.
Permission to publish.
Permission granted.
Oh, we're presenting a chart. We're presenting a chart. And they got to zoom in, zoom out, get it figured out. I'm sorry, guys, y'all. Thank you for being understanding. See, this is me. I have to figure this shit out slowly but surely. Because I don't know, the audio is only coming in one side.
Of abuse and explaining the demonstrative that's on the screen.
Yes, so the cycle of abuse, like I stated, is a cycle in which they trapped inside of an abusive relationship. And I know that the public is very familiar with some of these terms, such as or even the tension building phase, but I want to explain based on a social theory from 1979 of how we see someone staying inside the relationship with the tension building, right? This is right before the incident.
What is happening with this court? See, now it has no sound at all. That's not me. I haven't touched anything. Now it has no sound at all.
Physical,
there we go.
Economical, it can be
Y'all, I'm having a nervous
humiliation,
breakdown
it can be
day over this
intimidation,
court.
it could be a whole host of things. And it doesn't have to be a physical incident of arrest, right? So that's when the incident happens. In the reconciliation phase, where we're seeing about guilt, right? Sometimes the survivor feels guilt during this phase. This is the phase where I see survivors wanting to release the charges. This is why I see survivors wanting to recant or even fund the batterers or perpetrators funds and when they're in jail. This is when the perpetrator, either he apologizes or he blames the victim for what happened to them. And, oh, it wasn't as bad as it was. This is where a lot of the term gaslighting comes in. And it's basically a conversation back and forth between the survivor and the perpetrator where they're getting back into the relationship. It does not have to look like a honeymoon phase where you're getting flowers and all these things. That's why we no longer really use that term anymore. And that's why we use the phase calm. So in this phase, most likely the abuse is forgotten, the incident is forgotten. We just move on with life like this never happened. That's what I see the most in my field, in my personal observation in the field that I work in. It's just forgotten. It didn't take place. These things happen in relationships. We move on. But like I said, it doesn't always look like, oh, You're getting flowers, you're getting presents and gifts, and it doesn't always look like that. Sometimes it just looks like we're moving on with life.
And you kind of talk about in the incident phase, it could be verbal, emotional, and physical. Is it usually one of those three, verbal, emotional, or physical?
It could be a whole host of things. It doesn't always have to be fit into that box, because domestic violence is not a box. Every relationship looks different. Every incident looks different.
Now, in the field, is there also a concept of the power and control wheel?
Yes. The power and control wheel was created in 1980. It's a qualitative tool where 300 survivors were interviewed, and we use ground theory, which is a themes theory, to find different themes, similar themes, to create this wheel to show the tactics of the perpetrator.
And have you used a demonstration of that power and control wheel to explain how an abuser will exert power and control over a survivor?
Yes.
Now I'm going to show you what's been marked as State's Exhibit number 75. Do you recognize State's Exhibit number 75?
Yes.
And how do you recognize State's Exhibit 75?
It is the power and control wheel.
And would that help you today in your testimony and explain to the jury the power and control that abusers use in relationships?
Yes.
Your Honor, this time the state like limit State's Exhibit 75 for demonstration.
This is a demonstrative exhibit?
Yes, sir.
No objection to using it as a demonstrative exhibit.
Exhibit 75 is admitted for demonstrative purposes.
Thank you, Your Honor.
Every time they go to any of their videos or their charts, we lose sound in the courthouse.
Looking at State's Exhibit number 75. Okay, let me remove them. If you can, and what I'll do is I'll navigate
over here. Just tell me when I need to go up or down.
up or down.
So
Go down. Okay.
to show like the contributing factors and okay. Oh, that's
All right.
mm-hmm.
Okay. So if you can explain kind of the wheel, it's up, and if you could, you may have to step down just because we might not be able to on this screen.
Yeah.
So to explain to the jury what.
So I want to explain to you all what this wheel is, but I want to tell you why it's structured this way. So on the outside, so first, this isn't the first wheel. This wheel has evolved since 1980. And the reason why I use this wheel, because it's a very much gender neutral wheel, because we understand that domestic violence isn't just gender from man and woman, right? It is a whole host of genders, a whole host of communities that suffer from intimate partner violence. And it's structured this way because the physical and sexual violence is seen. Those are things that can be seen, so that's why they're on the outside of the wheel. And these are systems that contribute to intimate partner violence, right? Systems, isms, and things I train about when I'm out in the community trying to help people understand how these different systems could trap someone in a relationship, right? So on the inside, we're going to start with using intimidation. On the inside, these are factors or tactics you may not see when you approach or survive a domestic violence. You may not see intimidation. Mind you, these are all inside the spokes. You may not see someone having a fight over book. You may not see someone abusing text or using weapons as threats, right? Putting a gun on the table is not illegal. You may not see the emotional abuse. You may not see that person being put down. You may not see the humiliation, or you may not even think that that person is being humiliated or being exposed in that moment as a form of power and control. Using isolation. This is very important because this happens very early in the relationship. They isolate you to them and their support system, right? They don't want you to have any outside friends. They don't want you to have any outside family. They don't want you to have sisters, sorority sisters, or whatever is your support system. Sometimes this transfers, like it's parallel to economic abuse, right? Your livelihood. So what I see a lot in isolation is survivors being pulled away from their family, right? Being moved across country, or being told that it's abnormal to speak with your family members every day, right? They're trying to reduce your access to people so that others on the outside don't see the abuse that's going on inside the home. Minimize it, right? It wasn't that bad. What are you talking about? I'm minimizing the joke. I'm minimizing what took place, specifically on the cycle abuse incident. There's a minimization going on during the reconciliation phase. It wasn't that bad. You made it look like it was the end of the world, and it wasn't. Using children. That is a major, major part of why a lot of survivors stay in relationships, because they want to protect their children, right? That is just the natural part of being an adult. And sometimes when there's a separation, because this abuse can continue outside of the relationship. The relationship could end, but if you have that connection with children, we can start using the children as the go-between. We can start using the children as someone else to continue the power and control and the abuse. We can also use children to harass family members, use children to indirectly affect your livelihood, right? Calling your place of employment and things of that nature. Now we use privilege. So this has changed to use.
And they lost their sound. See?
Bible,
I hate that.
someone's race, their culture. Privilege can look a lot of different ways. In economic abuse, I always talk about you must have control of all the money, you must make the most money. No, it could simply be tampering with a survivor's car so that they can't go to work, right? Ruining credit, continuously getting evicted, invasion of accounts. It could look any way, but the whole goal is to take control of your economic livelihood. Using coercion and threats, that's in the definition. I'm going to coerce you to stay in this relationship. Coercion is really used a lot in the queer community. I'm going to out you.
His hair is beautiful, y'all. Y'all look at Mr. Attorney's hair down today. Beautiful, beautiful. And the sound keeps going out. That's not me. I don't know what's going. It's just in and out with the court as it pleases. I don't think it's any different on
This bill,
the other channel.
Relationship bill, we have so many different bills out right now, but it is the same concept, power and control.
Thank you. And in every abusive relationship, will you see every tactic used?
No.
In order to define a relationship as an abusive relationship, does there have to be like a magic number of events or physical violence or a certain amount of times that someone uses isolation to define that this relationship is domestic violence?
No.
How do you distinguish in the field, say, an isolated incident from a relationship that would be considered a domestic violence relationship?
So to explain an isolated incident, we look back at the definition of domestic violence. The definition is a pattern of coercive behaviors to gain and maintain control. That's what it is. And if there is a pattern, it doesn't take, it's an indefinite number, right? We don't have a certain number. We don't have a certain theme for it to fit in. As long as it fits under that definition and that survivor is explaining that relationship from beginning to end or in the middle, patterns of coercive behavior to gain and maintain power and control, or for the perpetrator to exert power and control, we define that as a domestic violence relationship.
Now, is there any literature regarding the various roles an abuser can play during a domestic violence relationship?
Yes. So there is trainings and information out there about men who batter, right? But we still use that foundation for all genders. And in that training and in that information, the roles that a perpetrator will play to gain and maintain that control is the hero, the judger, or the victim. In that relationship, we see that theme continuously circling and circling to show power and control against their intimate partner.
Okay, so you said it's the hero, the judger, and the victim.
Yes.
Can you explain the hero role?
So the hero usually shows up first, right? I'm saving you from your family. I'm saving you from your friends. I'm saving you from economic depression. I'm saving you from food insecurities. I am here to be a savior, to push you forward in life, right? And there's no infinite time on how long that will last. But yes, I'm the hero. I'm here to save this family, and I'm here to save you from yourself. When we think about the judger, let's go back to the hero. I have saved you. And then as the judger, you may say, the survivor may say, oh, now I want to connect with my family again. I feel like it's time. I think forgiveness is the right answer. Then I'm going to judge you for that, right? No, why would I save you from them? Why would you go to some place where they hurt you? Why would you interact with people who harmed you? I saved you from that. So I'm judging you in that because I don't want you to go over there, right? I want to maintain that power and control. So I'm judging everything you do when it comes to seeking outside support. And then the victim is, this is a basic answer of the victim. The survivor is now, perpetrator is like the perpetrator playing the victim. The survivor says, I'm leaving the relationship. This is not healthy for me. And then we play the victim role. Like, what did I do to you? I saved you, and now you're trying to leave me. I deserve closure. I deserve these things because I am the victim here. And you're leaving me for no reason, right? You're leaving me for no reason. I did all these things for you. It exerts this level of guilt that can keep a survivor in the relationship as well.
Is it unusual for a victim of domestic violence to remain in a relationship with the abuser after the abuser physically assaults them?
It's not unusual. It's very common.
And why is it common?
So we go back to coercion, we go back to reconciliation. It wasn't that bad. You did this to me. We could make this work. Everyone has heard the term, this will never happen again, right? So it's a level of guilt that the survivor is hearing, or a level of happiness because, wow, they've told me that this won't happen again. This person is actually owning up to what they did, and now we can move forward in a relationship.
Same question. Is it unusual for a victim of domestic violence to remain after someone verbally abuses or verbally assaults them?
Yes, it is very common for someone to stay.
Is it for the same reason that you kind of just discussed?
Yes. Or even sometimes survivors blame themselves when it comes to verbal abuse or emotional abuse. Like, I deserve that. I really was acting that way.
Is it unusual for a victim of domestic violence not to pursue criminal charges in the case?
It's not unusual.
Ms. Hilton, are you done with that exhibit?
Oh, I'm sorry. Yes,
That's
Your Honor.
okay. If you could take down your screen share.
Yes. And is it unusual for a victim, for a survivor of domestic violence to withdraw or ask for a temporary protective order to be dismissed or withdrawn?
It's not unusual.
Why not?
I want to go back to the reconciliation, that when we're reconciling, right? So the survivor may believe the perpetrator has changed. This is not necessary. This is we're overdoing it, right? Yeah, I believe that this is way too much. Like, I believe that you're going to co-parent appropriately, and we don't need all these parameters. You could be coerced into that, or a survivor can say, well, we're always going to have they told me that we're always going to have a third party when exchanging children. We're always this person is not going to do these things alone with me anymore. So, of course, I don't need this level of protection anymore.
And I use the term a temporary protective order. Can you define what a temporary protective order is?
So in Georgia, a temporary protective order is what the community would know as a restraining order, that you can't be within X amount of feet of me. You cannot be alone with me. You cannot be within X amount of feet. You cannot contact me indirectly or directly. You cannot use family members, friends, siblings to send messages. This is a complete stop of communication.
And in Georgia, to get a temporary protective order, is that a civil hearing? Like, are both parties present when at a civil hearing to get a temporary protective order?
Yes. So you're going to have a plaintiff and defendant, but it's a civil proceeding. It does not turn criminal until that protection order is violated. But it's a civil proceeding. It is done in front of a, depending on the county, a family court judge, or done in the protective orders office to have due process, because the defendant of that temporary protective order gets to deserve, constitutionally rights. They are able to do due process.
Now, earlier we talked about kind of isolation as it relates to the power control wheel. Hypothetically, if an abuser or perpetrator moves a victim to a location where she's unfamiliar, has no friends or family, can that be a form of isolation?
Yes.
How can that be a form of isolation?
So that can be a form of isolation because you are moving that survivor away from their support system. You are now around my family and friends, and they will be your influence at that time. So you have no immediate access to any support system when you're moved up and rooted from a place you know and are familiar with to somewhere that's new.
Hypothetically, if an abuser moves the victim to a neighborhood, or a perpetrator, moves a victim to a neighborhood for which he's familiar, he has friends, he has family in that neighborhood, he has neighbors in that neighborhood, and he never introduces his significant other to those individuals, can that be a form of isolation?
Yes.
How?
So that's a form of isolation where you are keeping the survivor in the home or away from the community so that the survivor cannot even create their own community, right? You typically, when someone moves to a new community, you end up creating your own community, right? If you don't know anyone, you would be introduced as someone's spouse, and then typically in a healthy relationship, that spouse gets to navigate that neighborhood, join committees, or do whatever they need to do to feel comfortable.
We talked about isolation, and if an abuser, can an abuser isolate you, strike that. If an abuser isolates you from your children, can that be a form of control?
Yes.
Are there times when a perpetrator uses family members to kind of step into the place to exert power and control over a victim?
Yes.
How can that happen?
So specifically, if you're isolated to your partner's family members, they can use coercion as well. They can use the children. They can use these same tactics of emotional abuse and minimizing and threats to keep you in that abusive relationship. They're just doing it from the outside, but they can still be enablers. They can enable the perpetrator's behavior and use the same exact tactics that a perpetrator would use to keep you in that relationship.
In your experience, if a survivor is being abused and maybe her family members, family members maybe see signs of that abuse and they want to confront the abuser. And the survivor stops them from confronting the abuser. In your experience, what are some of the reasons that the survivor will not want a family member to, say, confront or approach an abuser?
Your Honor, I object to individual instances of her experience.
Sustained. You can rephrase if you'd like.
Sure. Hypothetically speaking, if a survivor does not want his or her family member to approach or to speak with an abuser, is that a form of self-protection?
Yes.
How?
So when we think about the dynamics of domestic violence, when we have outside family members approaching the perpetrator, the survivor is going to take the brunt of the blame for that family member or friend approaching and accusing or exposing domestic violence, right? Specifically if the survivor is still living in the home. So it is a form of protection. And it also can be a form of protection for the children.
Now, as it relates to this case, what, if any, information did you have as it relates to this particular case here?
I don't have any information. As an expert, I come in blindly because I'm here to stay within the psychoeducation and the science of domestic violence.
Let me ask you this. Did you know that this was a murder case?
Yes.
Did you read any police reports as it related to this case?
No.
Did you view any temporary protective orders as it relates to this case?
No.
Did you listen to any interviews as it relates to this case?
No.
Did you interview anyone as it relates to this case?
No.
You spoke about earlier that you've been qualified as an expert in Georgia in about 47 cases. In those previous cases, have you had substantial information about those cases when you testified?
No.
Can you tell the jurors about being a kind of general expert? What's that?
So
A what?
A general expert.
General expert? I don't know what that means, Your Honor.
Sure.
I guess that's why she's asking the question.
right.
Why is it that you choose to have minimal information about the case?
I have minimal information because as an expert, I am not here to diagnose domestic violence, and I'm not here to prove guilt or innocent. I am an expert. I'm a social scientist on intimate partner violence, and that's all I can offer the court.
Are you getting paid to testify today?
Yes.
How much are you being paid?
$250 per hour.
And was your testimony today based on your education experience working with domestic violence survivors?
Yes.
Of course, indulgence for a moment.
Sure.
Let me ask you this. Hypothetically, if a survivor gives full custody of her children to the perpetrator's mother, can that in some way be used to exert some form of power control over a perpetrator?
Your Honor.
I mean, over a survivor.
I'm sorry. I object to this kind of using evidence and posing it as a hypothetical to specifically ask her opinion of that specific conduct.
Understood. Overruled. Go ahead.
You can rephrase?
Yes.
hypothetically, if a survivor gives full custody of her children to a perpetrator's mother, can that be used in some way to exert some form of power and control over that survivor?
Yes.
How?
So if the perpetrator's parents now have the children, they have control of the children. They make choices for the children, and that leaves the survivor powerless in that situation unless the survivor navigates to comply with the current guardian's requests, the current guardian's recommendations. It could lead to an imbalance of power from that parent. So yes, that can be definitely a form of exerting power and control.
Court's indulgence.
Sure.
Careful. Thank you. No further questions.
Thank you.
Thank
Mr.
you.
Samuel, questions for this witness?
I don't want to mess up my other ink.
Good morning. Good afternoon, Ms. James.
Good afternoon.
Not doctor yet, right?
Almost.
Almost. When will you be doctor?
May of 2026.
Excellent. You and I met only once before, right?
Yes.
A couple weeks ago. In this courtroom, right?
Yes, about a week ago.
I'm going to ask you some of the same questions as Ms. Hilton. First of all, you actually worked at the Fulton County DA's office for quite some time, right?
Yes.
How many years were you working there?
I started work in July of 2019 and I left in January of 2023.
Okay, so 4-ish years.
Yes.
Okay. And did you work with Ms. Hilton during that time?
Yes.
With Mr. Fawcett or Mr. Wilson?
No.
Okay. How many times have you worked with Ms. Hilton in a case?
So in the victim advocate role, we were assigned certain courtrooms. So I would only work with Ms. Simone if she was doing a case, if she was assigned to that courtroom or a case to that courtroom. And also she was the deputy, what we would call the deputy district attorney for the domestic violence unit. So she had minimal interaction with the bulk of the cases.
Asking you for a number somewhere between X and Y.
I can't really define a number.
That's not a problem. How many times have you testified as an expert in one of her cases?
I believe once.
Okay. Of the 47 times that you testified in Georgia, were they always for Fulton County?
No.
Percentage-wise?
If we're looking at the percentage, most, I would say maybe 95%
Fulton County.
were Fulton County.
Right. So 95% of 47 would be, I don't know, 45, something like that?
But also one of those cases was with the defense.
Okay. So there was only one occasion where you ever testified for the defense?
In Fulton County.
Okay. And all the other times you were testifying either for Fulton County or, I don't know, DeKalb, Gwinnett, Cobb, somewhere, correct?
Rephrase.
Well, I was just trying to do the arithmetic, but you said 47 times. One time you testified for the defense. The other, whatever, 44, 45 times you testified for the prosecution. And almost all in Fulton County.
Yes.
Okay. And so you're being paid now to be an expert instead of being a member of their staff and just coming in and testifying. They, meaning the prosecutors. Now you went out on your own and you get to bill for your time, correct?
Yes.
Okay. And do you bill for all your time or just when you're sitting in the chair?
I bill for all my time.
Okay. So when we're late starting court in the morning and you have to sit out there, you bill $250 for that too?
Yes.
Okay. We'll have to remember that, Your Honor. Do you know how much you've been paid, how much you've billed in this case, or how much your hourly has been in this case so far?
Not yet.
Well, I know you haven't finished yet, but estimate the amount of hours you've put into preparing to testify in this case.
I would say estimate at 3 or 4.
Okay. And you met with Ms. Hilton, obviously, correct?
Yes.
She reviewed the questions she was going to ask you.
Yes.
She reviewed the hypotheticals she was going to ask you.
Yes.
She told you, I'm going to ask you in particular about isolation. And she said, I'm going to ask you in particular about the family, having custody of the children, right?
Yes.
Okay. And you told her what your answers were going to be when she asked you those questions, right?
Yes.
Okay. Did she ask you any questions? I'm curious in preparing that you said, no, I'm not going to be able to help you on that.
No.
Okay. So she would say, I'm going to ask you X and Y and Z and A and B. And you said, yeah, I can help you with all those things.
Yes.
Okay. I'm going to ask you a few different times and in a few different ways about your knowledge of the facts of this case. But before I do that, I'll probably end just like Ms. Hilton did with that. Your testimony, in essence, is an opinion based on a lot of experience in teaching and meeting with people and reading about the characteristics of abusive relationships, correct?
Yes.
Okay. You said, I wrote it down, that you can't put abusers in a box. I'm not talking about punishment, talking about, one size fits all doesn't work, does it?
Yes.
That's correct, right?
Yes.
Okay, I asked a negative. That if you looked at did you say thousands maybe, or hundreds of abusive relationships you've looked at, more than just, a little bit, they're all different, right?
Yes.
Okay. Every relationship is unique, right?
Yes.
The abusers, and I'll just say the partners, whether they're gay, or lesbian, or trans, or male, female, or whatever, they can be wealthy and still have an abusive relationship.
Yes.
They can be poor, poverty-stricken, and still have an abusive relationship.
Yes.
There can be a family of history of abuse, a family history of abuse. In other words, generation to generation, correct?
Yes.
Sometimes you'll see partners for whom both sets of parents were in fact abusive, right?
Yes.
But sometimes you'll see partners for whom the parents, there's no evidence of any history of abuse in the generation above the one that you're looking at, right?
Yes.
I'm screaming it in my head, case one.
Some parents,
I knew what you meant.
again,
I knew what you
parents
meant.
of the partners are abusive to each other, right?
Yes.
Some parents are abusive to their children, correct?
Yes.
Including the people you look at who then become the partners in the abusive relationship.
Rephrase.
Okay, I've got two generations
Yes.
here. I got the generation above the partners being, however you want to characterize them, whether man, woman, or whatever, abuser and what was the other word? Driver, you said? What was you said instead of victim, we call them
Survivors.
survivor. And
Sir,
so
he couldn't answer this. Thank you. Y'all hear my mouth? My mouth. I need to make sure my mic wasn't muted. My mouth is just going. This line of questioning is stupid, Lois. I was trying to get my words out and they were not flowing properly. What? He couldn't even say the word survivor. He was saying driver. Get out. Pay attention, sir. I am bothered by that. He didn't even know what she was trying to say survivor, and he's over here driver. What was? Oh, okay. Calm down, Sheila.
generation above, sometimes they're abusive to each other, right?
Yes.
And
That's called childhood trauma, sir. Childhood trauma has, well, it has a lot to do with IPV, but I'm not sure that's what we need to be discussing because this is the case against Christopher and his relationship with Melissa. So I don't know where this guy's going.
both the abuser and the survivor may think of their parents and think this is normal. This is how I was brought up in my family, and justify it in their head, correct?
Yes.
And so what I was asking then was, is it sometimes the case that the parents of either the abuser or the survivor are abusive to that person?
Yes.
So abuse isn't always just limited to same generation, if you will.
No.
You can be abusive to your children, whether your children are adults or teenagers, or you can be abusive to your grandparents, right?
Yes.
Some parents spank their children, some parents don't spank their children, right?
Yes.
We wouldn't call that abuse unless it went overboard, correct?
I can't define that in this context.
Okay, not a problem.
Yeah.
I guess some parents are guilty of crimes, right? Parents of the partners you're looking at.
Yes.
You ever had a case, or do you have any experience in a case where the partners, excuse me, the alleged abuser and the alleged survivor, you know, the people you're looking at, that one of them is the child of a serial murderer?
No.
Would that be unusual?
I can't answer that in
Would
this
that
context.
fit, I'm sorry.
I can't answer that
Would
for
that-
you. I'm sorry.
Would that fit the dynamic that you're looking at, or would that be kind of outside the wheel and have to try to figure out what's going on there?
It sounds like out of the scope.
Yeah.
I agree. It's out of the scope. What her father was has no relevance to what her husband did or is accused of. Yeah, that.
Some
Look,
people run away
even
from
her
home
on the stand says outside the scope. I mean, come
at
on.
a young age, teenagers, right?
Yes.
Some people marry at a very young age, 16, 17 years old, right?
Yes.
Some people don't. Some people get married late in life, right?
Yes.
Some people are suffering from PTSD, perhaps veterans, right?
In general, yes. It's a diagnosis.
Yeah. And PTSD can be caused by a variety of things, correct? Not just being in Afghanistan, but maybe from your upbringing, correct?
I'm hesitating to answer that because I don't practice. I don't do clinical practice in Georgia. I'm not licensed in Georgia to do clinical. I'm only licensed in Florida. That's why I'm hesitating to kind of answer that, because I don't want to be unethical in the state of Georgia when it comes to like diagnoses and
Well,
mental health and a DSM-5.
let me put you at ease a little bit. I'm not going to ask you for a diagnosis today. You're not going to be sued for malpractice for anything.
I don't want to.
Just in general, I'm not a doctor either. You know, PTSD can be the result of all kinds of different kinds of trauma, correct?
Yes.
Post-traumatic, right?
Yes.
It could be something that happened in your childhood. It could be something that happened when you were a teenager. It could be something that happened when you were in the military, right?
Yes.
All those things can create PTSD. Is PTSD something that you see in your experience being part of the dynamic, the wheel, if you will?
No.
Okay. You don't see people who are suffering from mental health problems?
So when we talk about the definition of domestic violence, we practice as it is a choice. I'm trying to make sure I stay ethical.
Yeah, sure.
We practice it as a choice, you know.
Okay.
Yeah.
I guess what I'm asking is, I apologize if my question was lousy, but either the abuser or the survivor.
Did he really just say that? I apologize. It is. It's on the screen. I apologize if my question was lousy. Sir, your whole line of question has been lousy, okay? Just saying.
Might be suffering from mental health issues, correct?
Possibly.
Okay. If you look for the root cause of abuse, it might be, for example, infidelity.
The root cause, what we study is under the definition is exertion of power and control.
Well, that is the abuse. But the cause, if we treat it as something that's caused by something, either you and I, you're at least close to being a doctor. I'm nowhere close to being a doctor. Something causes either the person to be the abusive partner, and something causes the survivor to be susceptible to being. I'm not asking what abuse is. We'll get to that. I'm asking what causes it.
What causes is a choice. There's no diagnosis for domestic violence. There's no root causes of domestic violence. It is one individual making a choice that they believe is right to exert power and control over their partner.
Does the age and duration of the relationship have an impact on what would lead to abuse?
No.
No,
There may be problems with alcohol.
possibly.
Yes.
There may be problems with drug abuse.
Within
Possibly.
the relationship, yes.
Huh?
Oh, within the relationship, yes.
And there may be other, as I said, mental health issues involved that you have
Possibly.
to deal with in the relationship.
Personally, each individual, they may have their own.
Right.
Each
You don't
individual
believe, and I think you said this
situation
that
is
all
different.
Abusive relationships are the same either.
Yes, each one is unique.
Some may be more physically abusive, some may be more emotionally abusive.
Yes.
Very.
No expert would ever claim that all abusive relationships have the same characteristics or the same causes, correct?
Correct.
Your wheel, for example, that we had on the screen for a while. Remember this?
Yes.
This is demonstrative exhibit 75. I don't think we need to put it on the screen again, but I bet you've memorized this, haven't you?
Yes, it's one of my tools. So
Yeah. How often have you used this in court?
many times.
The wheel, each of the pie pieces, right? The wheel looks like a pie, kind of, right?
The spokes?
Well,
Yes.
you call them spokes, but I'm looking at the triangles as pieces of pie. Maybe that's because I'm thinking of food. But
Sure.
and each of these pieces of pie have lists of examples of how intimidation is used, how emotional abuse is used, isolation, minimizing children, privilege, economic abuse. Did Ms. Hilton review this with you and say, let's see how many of these factors we can find in our case?
No.
Have you talked to her about it before?
I spoke with her about the power and control wheel. Yes.
Okay. Did she talk to you about the fact that we are not involved in this case with ruining or destroying property? Are you aware of any evidence of that in this case, either through hypothetical questions or what you were told by the DA's office?
No, I'm not aware of any of
Anything
that.
to do with abusing pets?
I'm not aware of any.
Anything dealing with displaying weapons?
No.
Are you aware of any weapons in this case at all?
No, I'm not aware.
Okay. Are you aware of anything involving humiliation or playing games or anything like that?
No.
Are you aware of anything involving controlling what you do and what you read? Anything like that? Huh?
No.
Yeah. Are you aware of anything about joking about abuse? Do you know anything about that, or any hypotheticals asked you about that?
No, I don't know any.
Anything about shifting blame onto you?
No.
Anything about making you feel guilty about your kids?
No.
You know how old the kids are in this case?
No.
Do you know how old they are?
Sir,
You talked about a hypothetical.
they told you at the beginning they did not give her information on the case. She was here to discuss interpersonal violence and DV. What is he even doing?
Of placing kids with the supposed abuser's parents as being a sign of control. How about if the kids are like 6 months old and they're placed with the man's parents?
I have no knowledge of how old the kids are in this case.
Any evidence of using a 6-month-old or a 1-year-old to relay messages?
No,
Using visitation?
no.
Why is the prosecution not standing
Yeah,
up
I'm
and
kinda going
saying
through
this
your
is all
rules, but you know
irrelevant?
that, right?
She doesn't have
Any
facts
evidence
of the
of-
matter.
Treating the person like a servant,
No,
being the one to define gender roles,
no,
using race, culture, religion, or citizenship against one another?
no,
Preventing anybody from getting a job?
no,
Are you aware that Ms. Wolfenbarger was working at Waffle House?
no. I don't know.
Even she is
You were
laughing
asked
at his
about
questions.
Isolation. Would you describe isolation as having an outside job, having friends, having your sister working with you?
Extremely
Is
out of
that
line.
Isolation?
Depending on this, depending on what the domestic violence looks like.
I'm
Like I said,
disappointed in the
every
prosecution right now.
relationship is unique. Isolation doesn't fit in a box where it has to be one thing.
Right, but if the point of isolation is to prevent you from having, recourse to friends or communities, I think you said committees or whatever it is, you have a sister, you have a job, you have coworkers, that's not isolation, is it?
It could be for some relationships. I don't know any examples of that.
Okay.
I haven't interviewed anyone in this case.
Yeah, I mean, the problem with hypotheticals is if you add a few more facts, they get more and more confusing, right?
No,
Well, I just gave you more facts dealing with isolation. You said, well, I just don't know about that.
it wasn't confusing. I said that I haven't interviewed anyone in the case. So I just can't speak to that.
Well, I'm not asking about your experience. I'm asking about your expertise. Would you describe that as being isolation?
It all depends on the nature of the relationship. Isolation isn't just one thing. I haven't interviewed anyone, so I can't.
Each incident is
Answer that
different depending
question.
on the people. You cannot generalize this kind of thing,
Cycle of
sir.
abuse, which is Exhibit 79. Have you heard any evidence of a breakdown in communication? This is the tension building, number one. You heard any evidence about that or any hypotheticals about that?
No,
Have you heard any evidence of blaming, threats, intimidation, number two?
no,
Number three, abuser apologizes. Any evidence of that in this case that you know of?
no,
Gives excuses, blames the victim, denies abuse, anything like that?
no,
The fourth stage, calm. Any evidence of any of that in this case?
I don't have any evidence of this case. I haven't read any police reports. I haven't interviewed anyone. I'm not here for guilt or innocent. I'm just giving the science of what these tools mean and answering the hypotheticals as I'm asked.
Would
Thank you
agree
for
with
speaking
me
up because he's not
that
listening.
Many people who commit the crime of murder are not involved in an abusive relationship.
I can't answer that question because I don't know. I don't know.
You are aware from your experience that many people who are in an abusive relationship don't commit murder.
Yes.
I know you say you know none of the facts in this case, but you know some by virtue of the fact of the hypotheticals that Ms. Hilton said, these are the ones I'm going to use. Do these work? Can we use these, right? So you know from her preparing you that these are going to be the facts of the case. She wouldn't be asking you about something totally irrelevant, would she?
No.
Okay. Did you tell her to change any of the hypotheticals to
No.
make them?
Okay. No.
Fine, good enough. I think you said you have no opinion whatsoever about this case, right?
I was called to do the science. I can't diagnose domestic violence. I can't do guilt or innocent. I'm not, I'm not a prosecutor or someone of the court.
I mean, I understand that, and I appreciate it. The point is that your testimony is just general observations about the way lots of different relationships that are bad exist, right?
No.
I use too many words that aren't appropriate, right? There are abusive relationships involving power and control. Your testimony focuses on that, but you don't know anything about this case, right?
No.
Correct?
Correct.
Okay. And as Ms. Hilton said, you haven't read a single police report, right?
No.
If I ask, it's a problem with a negative question. That's correct, right? You haven't read a police report.
No, I haven't read a police report.
These jurors have heard, I don't know, a dozen witnesses. You didn't hear any witnesses at all, correct?
No.
You've not talked to the detectives in this case?
No.
Or the medical examiners?
No.
Family members of the people involved?
No.
Either the defendant or Ms. Melissa Wolfenbarger, correct?
No, I'm not an investigator. No.
Right. You haven't talked to her. Have you learned anything about her parents and her family and her upbringing?
No.
Even from watching a little TV or learning a little bit about the case?
No.
No idea?
I have no idea.
Okay. All right. You haven't talked to me about this case, right?
No.
We had one brief court appearance together last week, but other than that, you and I don't know each other at all, right?
No.
Okay. Those are all the questions I had.
Ms. Hilton, anything else?
Now, Mr. Samuel asked about different parts of the cycle of abuse. Could arguing be something that occurs in the tension building phase?
Yes.
Loud arguing, could that be something in the tension building phase?
Yes.
What about dragging of hair? Could that be something that be in the physical abuse or incident part of the cycle of abuse?
Yes.
What about dragging someone up the street? Could that be a part of the incident phase of cycle of abuse?
Yes.
Okay. What about markings on necks consistent with strangulation? Could that be evidence of an incident of
Yes.
abuse? Could a victim or survivor who drops a TPO after a private meeting with a perpetrator be examples of what can happen in the reconciliation phase?
Yes.
Can a survivor, who after meeting with her abuser privately decides to give full custody and control over her child, something that can happen in the reconciliation phase?
Yes.
And give full custody of her child to the abuser's mother. Could that be something that happens in the reconciliation phase?
Yes.
If a survivor after an alleged abusive incident, once she called the police, goes back to the abuser, could that be something that happens in the reconciliation phase?
Yes.
And are those some examples of what you've seen about how the cycle of abuse can occur in a domestic violence relationship?
Yes.
I have no further questions.
Thank you, Mr. Samuel.
No, thank you.
Okay, thank you, ma'am. You may be excused. You can step down.
Thank you.
Okay, ladies and gentlemen, it's about 3:05. We're going to take an afternoon break, and probably 15 minutes, maybe 20. And we'll be back in here at 3:25. Realistically, it's going to be closer to 3:30.
The luxury of that, we have Zoom, but they are still at break. So, give me a minute. I'm going to pull up something while they are at break. Give me just a second. Unmute, Sheila. Unmute. I'm going to play a song, and I'm going to go put Hector's lunch together, and I will be right back. They should be back in the next couple minutes because what time did she say? What time did she say? Let's back up and see what time she said. I don't remember what time.
Limiting instruction regarding expert testimony, not in there.
Oh, they talked for a minute. Okay, we'll go back. I'm sorry. I didn't realize they talked for a minute. Okay, get back here as quick as possible. Then 3:30. Okay, so they got 5 minutes. Okay, so let them get out. Let's hear what they talked about. And then I'll go get Hector's lunch.
Thank you all. You may be seated. Anything we need to put on the record regarding that witness or anything else before we adjourn for a break?
Can you put on the record at the bench conference where I asked for a,
Yes, thank you for the reminder, Mr. Samuel. So after the witness, Ms. James, was called, the parties approached, and Mr. Samuel requested a limiting instruction on the basis of 404 regarding other instances that would form the basis of hypotheticals about which Ms. James would be asked. The court, I advised you, Mr. Samuel and Ms. Hilton, that my ruling had been that those prior incidents were intrinsic, and that my understanding of the law is that intrinsic evidence is admissible for any purpose, and therefore no limiting instruction was required or appropriate. So I did not give one. Separately, though, Mr. Samuel requested that the court give a limiting instruction regarding expert testimony. Although it is not something I typically do, the state did not object. And so I indicated that I would give that instruction, which I did after the state offered Ms. James as an expert, and Mr. Samuel elected to defer his examination and voir dire of that witness and her qualifications until after the direct examination. So I instructed the jury. Any objection to the charge that I gave the jury, Ms. Hilton?
Not from the state, sure.
Mr. Samuel?
no objection. But I also asked for a prior difficulties instruction.
Thank you. You are correct for clarifying that. You did, in fact, ask for prior difficulties instruction. But as I said, my understanding is that because the evidence was intrinsic, it's admissible for any purpose and is not limited for as 404B or potentially prior difficulties evidence would be.
Understood.
Anything else?
No.
From the state, sure.
Okay. We're in recess till about 3:30.
So my curiosity got the best of me, you know,
Jeff, can you
because
move that, officer?
y'all know me. I got the curiouses like that. So she kept saying intrinsic evidence. I didn't know what it meant. It meant intrinsic evidence refers to information that's contained within a document itself rather than relying on external sources or testimony. So there's that. That's what it is. See, we're learning as we go sometimes. Okay, with that, I'm going to put a song on and go throw Hector's lunch together, and I will be right back while we're watching the clock.
Breathe deep, the air is wide. Stretch your arms, let the world collide. Step outside where the grass is free. Feel the earth beneath your feet. Watch the clouds as they roll and glide. Let the sun kiss your weary side. Take a moment, let it all unwind. Find the peace that's yours to find. Walk the path where the flowers lead. Hear the whispers of a world serene. Feel the warmth of a gentle breeze. Let your troubles drift with ease. Watch the clouds as they roll and glide. Let the sun kiss your weary side. Take a moment, let it all unwind. Find the peace that's yours to find. Walk the path where the flowers lead. Hear the whispers of a world serene. Feel the warmth of a gentle breeze. Let your troubles drift with ease. Watch the clouds as they roll and glide. Let the sun kiss your weary side. Take a moment, let it all unwind. Find the peace that's yours to find. Guitar hums in a mellow tune under the glow of the afternoon. Every chord a soothing embrace, guiding you to a tranquil place. Watch the clouds as they roll and glide. Let the sun kiss your weary side. Take a moment, let it all unwind. Find the peace that's yours to find.
The river rose without a sound, took the peace we once had found. Under the stars on a July night, now hearts are heavy in the fading light. The flags still wave, but the air feels torn. The 4th of July at night to morn. Memories drowned, love swept away. Texas skies weeping shades of gray. Hold on, though the water's wild. For every tear, there's still a smile. The sun will rise, though it seems untrue. In the heart of loss, love shines through. The flood has left a hollow wake, 1,000 dreams have dared to take. But in the wreckage, hands still reach for hope's soft whisper, love will teach. The flies above, they're watching still. Through the pain, through the chill, we'll find a way, we'll build anew. Texas strong, hearts will break through. Hold on, though the water's wild. For every tear, there's still a smile. The sun will rise, though it seems untrue. In the heart of loss, love shines through. Hold on, hold on, though the water's wild. For every tear, there's still a smile. The sun will rise, though it seems untrue. In the heart of loss, love shines through. Hold on, though the water's wild. For every tear, there's still a smile. The sun will rise, though it seems untrue. In the heart of loss, love shines through.
And they aren't back yet, and it is after 3:30 their time. I don't know, guys. They're never on. I don't think they're ever on time. I think they're never on time. I was looking for something, but I can't find it. Oop. Turn down the other volume. I was looking for something else, but I can't find it. Look, I'm going to share this for a minute. Y'all see this?
I know, but look at these greens.
This was a hailstorm at a golf course.
We're not gonna be able to play tomorrow. No. Or the next day. Holy Christ.
And this was recently, not too long ago. I was like, oh my gosh. That was horrible. There was another funny one I was going to show you. Oh, here we go. This one. I love this one. This is like the damn kids.
Mom putting gas because she got no man.
Why are you watering that?
Whoa!
So they can grow?
She's watering her baby so she can grow.
I don't know, baby. It makes mommy look prettier.
I don't think it's working.
No, she don't.
I
should have put that on it. Samaj,
Ma'am,
what are you doing?
wash the dishes. I'm taking a picture of me.
I'm not taking a picture of you, but you making a mess. You got water everywhere.
You got shoes on, though?
I got shoes on though. What that mean?
No.
Girl,
Me.
I miss my man.
No, you don't. Your man's gone. And my mom got pregnant with me. And she went to the hospital and take me out. And from her ass.
Damn kids. Damn kids. Y'all look, they're still not back. I'm waiting patiently. Patiently waiting. I don't know. I know. I do have to say that the DV talk was a little triggering for me. So you did. Let me pull it up. Hang on. What? Hang on. Let me open and crow. What the hell? What is Mel doing? What has he got going on? Let's see what Ikamel's got. I have no clue.
Uh-oh. I guess this guy's accused of being illegal. Oh, he tried to run for it. Oh my gosh. He said, I don't have anything.
What is wrong with people?
I don't have anything. Oh, man.
Why would they try and run?
Saying I don't have anything. I don't have anything. I'm just working. I'm working. I don't have
They
anything.
really are. They really are.
Oh, man.
He's saying they don't have nothing.
Did you vote for this? Wow.
Yo trabajo. Yo quiero estar con mi familia. Yo quiero estar con mi familia.
I work. I have nothing.
Yep.
I want to be with my family.
Yo vengo de trabajar. Yo quiero estar con mi familia. Yo no soy criminal.
I'm not a criminal.
Criminal. Yo no soy criminal. Yo no soy criminal. Yo no soy criminal.
Wow, this is crazy.
Yo no soy criminal. Yo quiero estar con mi familia. Brother. 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 Hermano. No, no,
But you know what? Look.
Courthouse. KBRC2 reporter
I mean,
Rochelle
this is
Turner
everywhere.
joins us
It
live
makes
near the
me
Immigration
so
Courthouse
angry too.
in Greens Point. Rochelle, talk to us about what you've learned throughout the day.
I mean,
Zach, good afternoon to you. I did see ICE agents inside.
And the thing is, you know, they're taking it's getting out of control the way things are happening. Let me see if I can fast forward this onto. Oh, here we go. Yeah, because I was watching this one when it happened. And they're just saying that
Now, for the past 2 weeks, our 2 Investigates team has been digging into which cases ICE is targeting. Yesterday, my colleague Robert Arnold was there when 3 people were detained at the immigration court on South Gessner near the Southwest Freeway. Now, all 3 men had asylum claims. They were accused of entering the country illegally, but have been allowed to stay in the U.S. while their cases move through court. Attorney Kim Bruno says more undocumented people are now choosing to self-deport.
they're choosing to self-deport because it's getting out of control. They don't want, he says he works in the area. Yeah, I mean, I don't understand why it's so bad. It's so bad. And I know here in the Houston area, it's been really bad. There, I actually live in a little town outside of Houston. And a few weeks back, one of our local auto body shops that does just basic repairs and stuff like that, they came in and raided the whole place. You know, of course, it was reported all over our Nextdoor app because people were panicking. So, I mean, we just have to watch out for that kind of stuff. Yeah, they're taking mom, dads, leaving behind their babies, the foster system. Yeah, they don't want to leave their family behind. It is so much. It is so much. Okay, I'm going to mute so I can walk Hector out, but I will leave this up and playing so that way if it does come back on, we will be right here where it picks up. So I will be right back. All right, see, I did all that, and They're still not back. I swear this court is never on time. I see people moving though. I see gray heads walking across the screen. What's up, me? You want to come see? You want to come be on camera? Come here. Come on. Get up here, baby. Your mommy's boy. I love. I know you're jealous, Lola. I know you're jealous. You're jealous. Baby's jealous. Hi, me. Mommy's boy. Mommy's boy. You want to see? You want to say hi? You say hi? I know Lola's being a pest. She's not happy. She's not happy. Oh, bless you. Oh, nasty. Nasty. Back up. Thank you. Oh, just sneezed all over me. Gross. Yeah, I'm with you, TCN. If they're taking care of families and they're not doing anything illegal, leave them alone. Let them do their thing. I don't believe in all that, just ripping people from their families, and it's a lot. It's very traumatizing. It's very traumatizing. And I couldn't imagine. These people, the ones in Houston that they did, they were actually going to court. They were in immigration court when that happened. It's not like, they weren't trying, because obviously they were trying to better themselves and take care of whatever situation was at hand, by actually going to court. And then, so that's going to scare everybody else and think, well, I don't want to go to court, because if I go to court, what's going to happen to me? Here, while we're breaking, I'm gonna share this one too. Oh, no, I didn't mean to copy that. I need to open in Chrome. Open in Chrome. So this is a short video. Well, actually, it's 30 minutes long. I don't want to play it right now. Well, you know what? This goes back to Mickey Steins. We were talking about Mickey Steins the other day. While we're still sitting here on break, we might as well roll with something, so I'm not just sitting here with dead air. So this is Brian Enton. And if y'all remember, court started. Okay, here, wait.
Terry, good
okay.
afternoon.
Oh, gosh.
Good afternoon.
All right, thank you.
CAROL.
Thank you, Lois. You're the bomb.
Dr. Carol, CAROL, Terry, TERRY. Terry, good afternoon. Good afternoon. Can you tell the court where you're currently employed? Well, I am currently employed as the chief medical examiner for Gwinnett County. Okay. And what are your duties as a chief medical examiner? Well, I am a forensic pathologist, and my duties involve investigating deaths that are reportable to my office under the Georgia Death Investigation Act. So these are deaths that are sudden, unexpected, unexplained, or due to non-natural causes. And as the medical examiner, my duties involve determining cause and manner of death. Cause of death is what it sounds like, what caused the person to die at this point in time. Manner of death is a way in which we categorize deaths for purposes of reporting on the death certificate. Okay. And where did you work prior to being employed at Gwinnett County? Prior to coming to work at Gwinnett County, I worked as an independent contractor for Dr. Gerald T. Gawitt, and that's G-O-W-I-T-T, who is the chief medical examiner for DeKalb County. And not only did we handle cases for DeKalb County, but we also covered medical examiner cases for Hall, Henry, Rockdale, and White counties. Okay. And prior to that, where did you work? Prior to that, I worked at the Fulton County Medical Examiner's Office as an associate medical examiner. Okay. And are you licensed to practice medicine in the state of Georgia? Yes, I am. And when did you become licensed? 1992. Can you go over for the jury your education and training? Yes, I can. In 1986, I graduated from Emory College of Emory University in 3 years with a double major. I have a Bachelor of Arts in Religion and a Bachelor of Science in Biology. From 1986 to 1990, I attended Emory University School of Medicine, where I received my Doctor of Medicine degree.
Hang on, I'm so sorry to interrupt you. I'm just going to ask if you'd slow down a little bit.
Okay.
I want to make sure the court reporter can keep
I
up
knew
and
she
you're a
was
little
going to
bit of a
say
fast
that.
talker.
I knew she was going to say
Thank
she
you.
was
That's
talking
okay.
too fast.
Please go ahead.
Thank you. So I am a medical doctor. From 1990 to 1995, I did a residency in pathology in the Emory University affiliated hospital system. Pathology, broadly stated, is the study of disease. And my 5-year residency involved a combined program of anatomic and clinical pathology. Anatomic pathology is tissue-based pathology and involves diagnosing disease states from tissues, such as biopsies, organs, or tissues removed from living people, as well as autopsy specimens. Clinical pathology is the laboratory medicine aspect of pathology and involves such areas as chemistry, hematology, microbiology, and blood banking. During the last year of my 5-year residency, I was allowed to work exclusively at the Fulton County Medical Examiner's Office in a subspecialty of pathology, forensic pathology. And forensic pathology is the medical legal investigation of death. So after the completion of my residency in 1995, I did an additional year of study in forensic pathology, also at the Fulton County Medical Examiner's Office. And this year of training outside of the residency was referred to as a fellowship year. And I did my fellowship year at the Fulton County Medical Examiner's Office in forensic pathology from 1995 to 1996. But because I already had a year of experience in that office, I was essentially treated like a junior attending and got to supervise other individuals in training as they rotated through the office. Following the completion of my fellowship in 1996, I stayed on staff at the Fulton County Medical Examiner's Office as an associate medical examiner. And that's where I picked up. I worked at the Fulton County Medical Examiner's Office from 1996 to 2004. 2004, I went to work for Dr. Gowett in DeKalb as an independent contractor and worked for him until the beginning of 2006. In February of 2006, I was awarded the medical examiner contract in Gwinnett County and took over doing the medical examiner duties for Gwinnett County. In Gwinnett County, the medical examiner position is not a county department, it is a contracted position. And my contract comes up for renewal every 5 years, where I have to rebid for the contract. And as I said, I was awarded that in February of 2006 and have maintained it to the current time. As we said, I'm licensed to practice medicine in the state of Georgia and have been since 1992. I am triple board certified by the American Board of Pathology in all 3 areas of pathology in which I have trained and studied: anatomic, clinical, and forensic pathology. I have personally performed between 6,800 and 6,900 autopsies. I've supervised individuals in training in approximately 700 additional cases. In my career, I have examined over 10,000 bodies because not everybody gets an autopsy. There's some bodies that I just do an external examination on and maybe draw specimens from to do additional testing, such as drug screen or other types of laboratory tests. And I have been tendered as an expert witness in the Superior Courts of Georgia over 455 times.
Your Honor, this time the state will move to tender Dr. Carol Terry as an expert in forensic pathology.
I am afraid to object, Your Honor.
Go ahead.
Now, can you tell the jury what an autopsy is?
Okay. An autopsy is a medical procedure by which a body is examined, both externally or from the outside as well as internally, looking at the organs to evaluate the extent of disease and or injury.
And who or what factors determine whether or not an autopsy is performed?
Well, as I said, for us as medical examiners, it's dictated by state law, which cases are reported to the medical examiner's office. And again, these are deaths that are sudden, unexpected, unexplained, or due to non-natural causes. And then once it's reported to the medical examiner's office, it is left up to the discretion of the medical examiner what type of an examination is conducted, again, with the goal to determine a cause and manner of death for purposes of reporting on the death certificate.
Okay. And the procedures that you've testified to, are they generally accepted in the medical community?
Yes.
And you tell the jury, you familiar with Dr. Joseph Parker?
John?
John Parker, excuse me.
Yes, I am.
And who is Dr. John Parker?
Dr. Parker was a mentor of mine. He worked at the Fulton County Medical Examiner's Office and also in Bibb County as the medical examiner in that area. He was responsible for some of my training. And ultimately, when I went to DeKalb County to work for Dr. Gowett, it was because Dr. Parker had stepped down from that position. Dr. Parker, I worked with him in the Fulton County Medical Examiner's Office when I came on staff there. I think and thought the world of Dr. Parker. He passed away in 2012.
Okay. And was he the medical examiner that was, I guess, the head medical examiner that examined the remains of Melissa Wolfenbarger when they first came in?
Yes, he was the medical examiner who was on duty the day that the remains of Miss Wolfenbarger were discovered.
Okay. And at any point, did you assist in any type of investigation or analysis as it relates to the remains of Melissa Wolfenbarger?
Yes, I did.
Okay. And what period of time are we talking about where you would have been involved in any type of analysis regarding those remains?
My first direct interaction with the remains occurred in February of 2000 when I was turning over the skull along with some other skulls to the state's forensic artist, Marla Lawson, to do some facial reconstructions. I had a case of mine from 1998 that I wanted her to do a facial reconstruction on, and she had recently completed some training. Her skills as a forensic artist were legendary in the police department, but she had adopted or had taken on some new training in doing facial reconstructions off of the skulls using clay or paper mache. And so that's when I made her acquaintance in February of 2000. She came to my office to get the skull of the case I was handling, but she said, if you have any others that you want reconstructions on, she said, I'll bring a U-Haul if I have to, give me all that you have. And she, was taking on that work, and I had amassed the reports associated with these different cases, as well as investigation summaries, and was turning them over to her. And when she looked at this particular skull, she raised the question of the sex of the skull, because it was indicated to be a white male. And Marla, if you knew her, she was very modest, even though, exquisitely talented, and said, this looks like a female to me.
All right.
Sustained.
All right. Let me ask you this. At that time in Fulton County, were you working with investigator Tina Miller?
She was a detective with the Atlanta Police Department, yes.
Okay. Did she also assist the Fulton County Medical Examiner's Office with investigations related to missing persons and or death investigations?
Not death investigations, missing persons and unidentified remains.
Okay. Were you aware whether or not Detective Miller went out to that location where Melissa's Wolfenbarger's remains were located at any point during the investigation?
Yes, she did.
Okay. And you familiar with the location being Avon Avenue in Atlanta, Georgia?
Yes, I am.
And is that in Fulton County?
Yes, it is.
Tell the jury what happens when, say, a body or remains come into the medical examiner's office.
Well, when the body comes into the medical examiner's office, the medical examiner on duty determines what kind of examination is going to be conducted on the remains. And then depending upon the case, that dictates what is done. Most of the time, the bodies are intact. And again, they may get what's called an external examination, just an outside viewing of the body and drawing of specimens for additional testing. or they may get an autopsy where the body is opened. And there may be a complete autopsy. In Fulton County at that time, we did not do limited dissections. We only did complete autopsies. So if an autopsy is done, it involves opening up the body and examining and removing the brain as well as the organs of the chest and abdomen and pelvis. And in the course of the examination, specimens are collected for potential additional testing. Again, it depends upon the nature of the case.
Okay. And any observations or conclusions, are they documented in any form during that process of performing the autopsy?
Yes, typically the examinations are documented with written notes and or dictations that are then converted into a final report.
And is there other forms of documenting the process of the autopsy itself?
Yes, also photographs are taken typically in the course of the examination.
Okay. At the conclusion of the autopsy, is there a process for reviewing or discussing observations that are made during the autopsy?
I don't know necessarily if at the conclusion of the examination, but in the Fulton County office, as we were associated with the training program through Emory, we routinely had teaching conferences and conferences where we would sit and review all of the slides that were taken, because at that point in time, things were done with 35 millimeter and slides were created. And every week we would have one or two conferences where we would go through all of the slides.
Okay. Now, in preparation for your testimony today, did you review any documents and or photographs associated with the autopsy of Melissa Wolfenbarger?
Yes, I did.
And what did you review?
Well, I reviewed, it turns out I had case notes that I had collected back at the time when I did this, when I was doing this review of the case, because I was very much interested in trying to identify remains. So I had copies of notes from the file, including some of the notes that I had made documenting some of the actions I had taken to try to get the remains identified. I also reviewed Dr. Parker's report. I reviewed any investigative reports that were in the file, as well as any photographs that were provided to me, because I did not have actual photographs from the examination.
Okay. And at any point during your work that you did associated with this case in particular, did you have an opportunity to either review any of the remains of Melissa Wolfenbarger? And you could describe that for the jury.
Yes, I did.
And when did you do that?
Well, in February of 2000, when I was turning the skull over to Marla, that was my first time that I had an opportunity to look at the skull.
Oh, okay.
And I looked at the skull.
All right. And discuss any other opportunities that you've had to look at the remains of Melissa Wolfenbarger.
And after she was identified, I had the opportunity to go and retrieve some of the specimens that had been collected to follow up on requests made by the Atlanta Police Department's Detective Calhoun to submit specimens to the Georgia Bureau of Investigation, specifically for some drug testing.
Okay. And when you say specimens, are you referring to the extremities of remains that were located?
It was some soft tissue from the extremities, yes.
Okay. All right. Now, what, in terms of, initially, I believe your testimony that there was a process of conducting an identification. What did you do to identify the remains?
Okay. And then two, I've also neglected to mention, also in the course of doing this, there were times when I went back to the remains, specifically the skull, to extract teeth or to take additional bone to submit for potential DNA analysis. So that was something else I also undertook with the knowledge of Dr. Parker to try to facilitate the identification. So what else I did in addition to collecting and submitting specimens for DNA analysis was, again, just became aware of features associated with the skull. For example, I did not need my records to refresh my memory that the skull had one filling in tooth number 31. that's something I've remembered all these years. There was one filling in that tooth. And that was something I was aware of as I was checking records and any cases came to my attention. Also, at this point in time, when I was in Fulton County, I did have an interest in trying to identify unidentified remains. And I had a computer program where I took missing persons reports and locations of where people went missing and plotted them on this map along with where we had unidentified remains, trying to look and see if there's any kind of spatial relationship between where people have gone missing and where remains were found. So this is something is just about being aware of who's missing and who we have who are unidentified in our morgue. Some people have various other research interests. This was something I was very much interested in because as a forensic pathologist, one of our big goals is to answer questions. And to me, there's no bigger question than who somebody is. And that was something that was of interest to me. And so I was happy to do whatever I could to try to facilitate the identification in this case. And especially since Dr. Parker was kind of part-time with our office, so he wasn't always there. But this was something that was always on my mind.
Okay. And what was the process for identifying the skull that was retrieved in April of 1999?
Or how the skull came to be identified?
That's correct, yes.
Okay, because we had made attempts to have DNA pulled from the skull from the teeth.
Objection. Reapproach.
Sure.
Hey, Cindy. You're late, love. It's okay. You'll catch up. You'll catch up, babe. Yeah, I'm a scheduler. I'm a stickler for schedules, and I've decided that 1 p.m. Central Time is a good time for me because it just is. And then I feel like if I start at 1, that usually gives us enough time to wherever I'm doing trials from. Yeah, I can usually, which this trial has been off the rails with silliness today and my silliness, but with me starting at 1, that gives me enough time to be able to skip through all the breaks, and I can pretty much condense the 6 to 8 hour day into about 4 hours. And I totally love that. So then I don't have to, wait with all the breaks and stuff. So part of my style, Yep. Love to skip. It's just, it's a thing for me. It's a thing. Speed trialing with Sheila. That's where I'm going with this. We got to learn, take a few curveballs and work with it until we figure out my exact niche.
And as far as the was the Fulton County Medical Examiner's Office able to retrieve any dental records associated with this case itself?
Yes.
All right. Did you have an opportunity to review those records along with Dr. Hopkel?
Yes.
And was that the basis for the determination of the identification of the skull?
Yes.
Okay. All right. Now, I'm going to hand you.
And they mute the sound again.
Your Honor, with the court's permission, I'm going to hand Dr. Terry the following exhibits. I'm going to read into the record.
Yes, sir.
Exhibits 34, 36, exhibits 40 through 49, exhibits 51 through 52, exhibit 54, exhibit 56 through 57, and exhibits 60 through 61. All right. Terry, I'm going to hand you.
Hang on just one second. Can you come here, please? Go ahead, Mr. Fossett.
She's carefully flipping through these papers. Take your time, ma'am. Take your time. We want you to get all this right. Yeah, I found another ICE story. It's just something that recently broke out of Georgia. So or Indiana, I think. Indiana. He was found in a Georgia ICE facility. Quite interesting. It's just a little short one. Oh, here, and let me drop Cheryl McCollum's podcast in there too. Cindy.
Okay.
Okay. And after viewing those photographs, do you recognize those images as being associated with the remains of Melissa Wolfenbarger?
Yes, I do.
Do you recognize those images as being associated with the same remains that you viewed at the Fulton County Medical Examiner's Office in 2000?
Well, this doesn't specifically show the skull. Those are the remains I remember actually seeing, but I am certainly familiar with the photographs.
Okay. And are they a fair and accurate representation of what you recall observing?
Yes.
Yeah. This time, the state will move to tender into evidence. States Exhibit 34, 36, 40 through 49, 51, 52, 54, 56 to 57, and 60 through 61.
Mr. McDermott?
No objection.
Okay. They are admitted.
Now, what was your recollection after reviewing the documents as to when each of the skull and the extremities were located?
Well, the skull was located on April 29th of 1999, and the extremities were located June, let me double check here, I can't remember the 2nd or 3rd, also of 1999. So let me find this. June 3rd, 1999.
Mr. Fawcett,
Yes.
are you preparing to publish those photographs?
No, I'm not.
Okay, just
No, I'm not.
making sure we have a heads up before we do.
Absolutely, Judge. I am publishing State's Exhibit 2. So I want to turn your attention to this State's Exhibit. Is that area in itself familiar to you?
Just by virtue of the names, I don't recall ever having been out there myself.
And you recognize that as being the location where the skull and the extremities of Melissa Wolfenbarger
Well,
were
I'm going to
located?
object, Your Honor. She says she didn't have any knowledge, personal knowledge in this area.
I'm not sure that's exactly what she said, but overruled. Go ahead.
You recognize that location, the street itself, as being the location where the remains, the skull, and the extremities of Melissa Wolfenbarger were located?
Yes, as I said, I'm familiar with the names, but I can't say that I directly went to that location, but I in my mind, had the skull associated with Avon Avenue.
And looking at that photograph, based on your review of your notes and your recollection, the image depicted in State's Exhibit 2, is that generally the close proximity in which the remains, extremities, and the skull were located?
Yes, that is my understanding.
I do plan on publishing photographs at this point, Judge.
Okay. So ladies and gentlemen, I told you that I would give you a heads up so you could sort of prepare yourselves that probably the next series of photographs are going to be somewhat graphic. Now, for those of you who are in the gallery, I encourage you, if it's not something that you want to see, to make arrangements so that you don't have to see it. Go ahead, Mr. Fawcett.
Yes.
I don't believe they'll show them, but just in case.
Now, Dr. Terry, you were testifying as to your, I guess, ability to review and examine the skull of Melissa Wolfenbarger?
Yes.
Okay. And I'm publishing State's Exhibit 16. And just, could you describe the state of the skull that it was in when you viewed it?
All right, in this photograph, this is a decomposing head that was in the roadway. This is the head that I saw the skull from when I mentioned that I was turning the skull over for reconstruction purposes. But again, this is a photograph I'm familiar with as it pertains to the day that the head was found in the road there at Avon Avenue on April 29th, 1999.
Okay. And after viewing the skull, were you able to determine if there was any damage to it?
Yes, there was damage to the skull.
And what type of damage are you referring to?
On the left side of the skull, there were some fractures, and there was some bone in the roadway that were described in the report, as well as in an adjacent plastic bag. It appeared that the skull had been struck by a vehicle in the roadway.
Okay. And what does post-mortem mean?
Post-mortem means after death.
And is there a distinction between injuries you would, I guess, damage to flesh or bone? Is there a difference between, I guess, pre and post-mortem?
Or ante-mortem, post-mortem, yes. Before death versus after death, yes, there's a difference.
And what is it? What differences would you observe?
Well, typically differences that you see in ante-mortem injuries, the person's alive, so they still have a blood pressure, there's blood flow. And so when an individual is injured ante-mortem or before death, you have bleeding that's associated with injury. Post-mortem or after death, there's no longer blood flow, and these injuries don't bleed.
I'm now going to show you what's been admitted at State's Exhibit 36. Can you tell the jury what we're looking at?
Okay, yes, this is one of the vertebrae that was associated with the head that was or the decomposing head that was found in the road on Avon. And this is one side of this, it's a cervical vertebra or a bone that's from the neck area. And you can tell because, can I touch the screen?
You can, you can enable that function and you can actually tap on it, draw on it in colors.
Okay, let's see.
There's a button, I think it's off to the left on the bottom of the screen.
Okay. These structures here in this vertebra identify this as being a cervical vertebra or a bone from the spine in the area of the neck. And as we look at surfaces here of the bone, specifically those are articular surfaces where the bone would interface with adjacent vertebrae or bone. So in looking at this surface of as well as in this area here, this is where the bone would articulate or interface with the adjacent bone of the spine. And based on the review of the report as described by Dr. Parker, this would be the third cervical vertebra. So 3 down from the base of the skull.
I'm going to show you State's Exhibit 37. I can offer no assistance with getting the marks off the screen there.
I think there's a clear button on the maybe bottom right.
There's something that says leave.
I don't think I want you to leave.
Nope.
No, ma'am.
Nope, sorry.
I might be in distance.
Go ahead. Yes.
Again, I will repeat myself. I think they need a technology expert hired for every court in the United States. So we don't have to have the lawyers going up and trying to do this or all this failed audio situations. Just my opinion.
Okay, all right. Okay, so this is the flip surface of that vertebra. And in looking at this surface here, specifically, oops. Can we bring that function back up? Okay. Specifically, these areas all appear to be kind of shaved off to the same level. And again, this is the reverse surface of that vertebra.
Now, when you are performing autopsies or working at the medical examiner's office, do you often use instruments to assist with that?
Yes, I do.
And what types of instruments do you use to, say, cut through bone or hard materials while you're working?
Typically, I use an oscillating or striker saw where I have a blade that will either spin or go back and forth to cut through bone. Another tool that I commonly use to cut through bone are basically like loppers, kind of garden shear type things used to cut like small tree branches, and we'll use those on ribs to remove the chest plate. Typically, we'll use the striker saw or the oscillating saw to open the head and to take sections of bone.
Now, did you also, were there also photographs of Ms. Wolfenbarger's extremities included in the photographs itself?
Yes.
Right. And did those extremities have flesh on them?
Yes, they did.
Okay. And let me ask you this. Do you recall either through photographs or reports how the condition that the remains were found in?
Yes, I mean, they exhibited decomposition and had been dismembered or cut.
What about how the remains were stored?
There were plastic bags there. For example, with the skull. There was a plastic bag nearby, but the skull was in the roadway. And then the extremities were located in plastic bags. One set of remains, my understanding, was outside of a plastic bag.
Okay. And turning your attention back to the skull, and that's Exhibit 16. Can you tell the jury, was there any sign of insect activity on the skull itself?
Not that I saw in any of the photographs or that I saw described.
Okay. Republished in States Exhibit 16. And what does that tell you, the absence of insect activity, maggots, fly larvae on the skull of Melissa Wolfenbarger?
Given the condition of the skull, that it was somehow protected from insects getting to it, flies getting to it. So understanding that there was a plastic bag nearby, most likely it had been in that plastic bag soon before it wound up in the roadway, because otherwise flies would have been attracted to it.
Okay. So if this skull had been out for a day or a full day, you would expect to find insect activity?
Yes, I would expect flies to have gotten to it and have laid eggs on it.
What is the impact of it being, say, double tied in a plastic bag? What is that impact on that?
Well, again, I don't know about double tied, but at least somehow being protected from insects getting to it. That would keep flies from being able to get to the remains and deposit eggs, and which then turn into maggots.
Okay. And does the storing of the remains in a sealed compartment like a plastic bag, does that impact any determination on the timing of death, or does that impact that at all?
Yes, I mean, it makes it harder because of the fact that it is, well, first of all, you don't know where it's stored, and it's confined in a plastic bag, which is going to interfere with decomposition and things of that nature. So it's going to make it harder.
Okay. And was your indication that the image depicted on States Exhibit 40, an image of a leg of Melissa Wolfenbarger, was your indication that that was in a protected plastic bag as well?
It would just, again, appear to be so, because again, we don't see any insect activity exhibited by this leg. So I would say that it was somewhere where it was protected from insects getting to it.
Okay. And you testified that there was some type of, something consistent with the saw on, I guess, the neck, the vertebrae that you testified to. Is that correct?
That is correct, and that's based on my observation as well as Dr. Parker's report as well. Again, looking at those surfaces, they appear to have been cut.
And were there other extremities or parts of Melissa Wolfenbarger's remains that also appeared to have the same type of saw cutting marks on them?
Yes, there were.
Okay. I'm going to show you States Exhibit 41. Can you tell the court what we're looking at?
States Exhibit 41, this appears to be the right lower leg and foot.
Okay. And States Exhibit 42. Is that the plastic bag or a photo of one of the bags that the remains were stored in?
Yes, this is a photograph of one of the plastic bags that was associated with the remains.
Is that the type of storage vessel that could prevent insects from getting access to the remains inside?
Yes, if it's secured.
Is that also the type of storage vessel that could make it difficult to determine a time, a PMI?
Correct.
Time of death?
Yeah, postmortem interval, yes.
Okay. Is that something that you typically try to make an evaluation, the PMI postmortem interval, during your autopsy evaluation?
Well, I wouldn't say specifically, but it's something we generally write down descriptions of decompositional changes that can be used to opine as to a postmortem interval.
Would the temperature outside, say the weather conditions, would that impact it?
Yes, I mean, it depends on where the remains are. I mean, where are they stored? How are they stored? Temperature is certainly a big determining factor.
Okay. What about, you testified to this, what about insect activity?
Yes, insect activity, animal activity as well.
All right. Did you see any signs of animal activity on the remains of Melissa Wolfenbarger during your evaluation?
No, I did not see any evidence of animal activity on what I had to examine or on the photographs.
And what would you observe if you'd seen evidence of animal activity?
Okay. Typically think about, like, say, dogs or carnivore type activity, chewing, gnawing on the bones, tearing of flesh, but especially with looking at the bones, looking at gnawing or scratching, and I did not see any of that indicated on the bones.
Okay. Show you what's been marked as State's Exhibit 43. Can you tell us what we're looking at?
That looks like some type of an article of clothing, maybe a sock. I don't know. It looks kind of muddy.
And State's Exhibit 46, what is that?
State's Exhibit 46 is the left foot, again, showing decompositional changes and protruding out of the soft tissue. I see a segment of bone that's broken.
State's Exhibit 47. Can you tell us what we're looking at?
State's Exhibit 47. This appears to be part of an upper extremity, so upper arm and forearm.
And State's Exhibit 48.
State's Exhibit 48, again, this looks like some type of article of clothing, maybe sweatpants that are dirty and appear to be kind of breaking down or degenerating.
Okay. I'm now showing you Exhibit 51. Can you tell us what that is?
Okay, State's Exhibit 51 are the various portions of the extremities with flesh removed from some of these bones, and they're kind of placed out on the table.
Okay. And State's Exhibit 54. You know what that is?
Okay. Yes, State's Exhibit 54 is one of the bones showing a series of kind of roughly parallel disruptions of the bone, referred to as tool marks. These appear to be superficial cuts in this bone.
All right. Now, can you tell the jury, is it different cutting bone with flesh on it versus cutting a bone that's been defleshed?
Yes, there is.
And what is the distinction, or what differences in those experiences have? Can you tell the jury?
Yes, it's harder to cut through bone, specifically with the types of saws that I use when there's flesh on there, because it just doesn't cut well through soft tissue or flesh. The types of saws that I typically use, the oscillating saws, are very good cutting bone, but not soft tissue.
Okay.
And it tends to catch on the soft tissue.
And when you say tends to catch, what does that mean?
The teeth tend to be somewhat fine, and the tissue gets in there, and it just kind of snags it, and again makes it hard to control, and difficult to cut.
Showing you State's Exhibit 56. You tell the jury what that is?
Okay, State's Exhibit 56. We're looking at bones from a lower leg. The thin bone that's at the bottom of the screen is the fibula, which is the thin bone that's in the lower leg area. And you can see the superficial cuts on it. And then the bone above it that looks more irregular, that's the tibia, and it is more broken than cut.
And you say superficial cuts.
Whoops.
Are you referring to that portion in the screen depicted now?
Yes, I believe that was in the previous exhibit.
Okay. And State's Exhibit 60. Is that further example or signs of some type of mechanical device coming in contact with the bone of Melissa Wolfenbarger?
Yes, it is. That's an end of a bone that has been cut.
Okay. All right. Now, Dr. Terry, based on your review of the photographs and reports, are you able to make an independent determination as to the cause of death of Melissa Wolfenbarger?
Yes, I can.
And what was the cause of death of Melissa Wolfenbarger?
The cause of death is ruled by Dr. Parker, or my opinion?
Your opinion.
Okay, which I think are kind of subtly different. But my opinion is that the cause of death is undetermined due to dismemberment with concealment of the remains and decomposition, and actually, and also with incomplete recovery of the remains because the torso was not recovered.
All right. What can't you determine based off the things that are missing, the remains that are missing of Ms. Wolfenbarger?
I'm sorry, can you ask me that one more time?
Different way. Did you have enough? Let me ask you this. Were you able to tell if Melissa Wolfenbarger was strangled?
No.
Why not?
Because of the decomposition of the remains and the lack of neck structures to examine. That makes determination of whether or not strangulation has occurred very difficult, if not impossible.
Okay. And can you determine whether or not Melissa Wolfenbarger was stabbed to death?
No, cannot.
Why not?
Again, we're missing the torso. Someone could have been stabbed or had other injuries inflicted on the torso that would have been responsible for the death, but you don't know because you don't have that part of the body to examine.
Is that the same difficulty you would have trying to determine if she was shot?
Absolutely, yes.
And is that ultimately why you're saying undetermined?
Yes, because the cause of death is undetermined here because can't say precisely how she died, and it is confounded by the fact that you have incomplete recovery of the remains. They've also been dismembered. There's been concealment of the remains, and there's decomposition.
Okay. Now, what would you say as to the likely cause of Melissa Wolfenbarger's death?
Objection. Speculation.
She's an expert.
You want to approach for a moment?
Sure.
I'm not sure she can give a cause of death unless like there was like gunshot wounds or something like that in the skull that was found. I mean, they can't just say dismemberment. That's not a cause of death. I don't know. I mean, I understand his objection. I do. Because I think it would be pure speculation, whatever she says. Unless, like, the skull was crushed or something like that. which it was not. So interesting. Lola's being good for the moment. Here. Say hello, Lola. Say hi. She's momentarily being good. It won't last. Yeah, I know. That's what I'm saying, Cindy. She said she couldn't because the torso wasn't there. There's no way for her to, I mean, so it'd be pure speculation, whatever, she says. I mean, it's so, I don't think they can bring that
Austin,
in.
if you'll rephrase, please.
Yes. Dr. Terry, is it likely that Melissa Wolfenbarger died of natural causes?
Given the circumstances, I would say that's very unlikely that she died of natural causes.
And if you could articulate why it is, your determination is unlikely that she died of natural causes.
Again, the body's dismembered. There's an attempt to conceal by placing it in plastic bags. I don't have, as far as I know, she was a young female. I have no information about any significant health conditions, but even so, the fact that she's dismembered and concealed is very suspicious for some sort of non-natural death.
Okay. And when you say suspicious for some type of non-natural death, could you be more specific? Are you referring to a homicide?
Yes, I'm saying that it's very suspicious for homicidal violence, given that she's dismembered, concealed. That is very suspicious. I can't say exactly how, but it is very suspicious.
All right. And the marks, the cuts, do you have a determination as to whether they're ante or post-mortem?
Yes, I'd have an opinion that it's most likely post-mortem.
And why is that?
Well, first of all, we don't see any discoloration of flesh associated with that. Second of all, just in terms of practically speaking, it would be very hard to dismember somebody while they're alive, and especially with the marks that tightly aggregated. You'd need to have somebody incapacitated or very significantly restrained to do that. And again, this is most consistent with something that has occurred post-mortem or after death.
All right. Now, in terms of the manner in which a homicide could have occurred, if say, for instance, Melissa Wolfenbarger was strangled, would you expect to see, like I said, the presence of blood in and around the surrounding remains themselves?
No, would not.
Why is that?
Strangulation typically does not result in the liberation of blood.
Okay, and considering that possible manner of death, as well as the fact that,
I'm sorry, you said manner of death, that's a cause of death when we talk about strangulation. I'm sorry, I just want to be precise about that.
Let me ask you this. Did you, when you were doing your evaluation, did you consider the possibility that she was murdered at that location where remains were located?
I mean, that's a consideration, but I don't think it's a particularly good or valid one.
Okay, so your I guess your consideration during the autopsy was that the remains may have been placed there. She may have been murdered somewhere else.
Yes, if she were murdered, it was most likely somewhere else.
And just referencing things that could impact a timing of death or make that determination, would you have been able to tell if the remains had been, say, refrigerated?
Not necessarily, no. I mean, but again, she's been dismembered and she's in plastic bags. The remains could have been anywhere.
And if it had been, say, the remains were refrigerated, how would that have impacted a time of death determination?
That would slow down decomposition, much like if you take any meat and put it in your refrigerator. The refrigerator versus the freezer, it will slow how it degrades.
Okay. One moment, Judge.
Sure.
Don't compare it to meat. Now I'm not going to eat for the rest of the day. She just compared that to meat. That was just, putting it in your refrigerator. No, thank you. Lola's over here cutting up. She done chewed a back of a remote that I don't even know how she got it because it was on a table she shouldn't have been on. And then she brought me something else. It's a little it's a connector for to connect two audio wires together. She was chewing on this. She's a chewer.
Yeah, can I approach?
Sure.
Now they're approaching. It's interesting that she is in all black as a medical examiner. I went through a phase of wearing purple for probably about 5 years. All I would wear was purple tops. Had to be purple it had to have purple in it. And then when I owned my motorcycle company, all my tops for that I wore for work were all purple.
All right for the jury.
Oh, they're dismissing the jury. What is happening? Look at that sexy hair that man's got today. Ooh. Barbecue sandwich sounds good. Mrs. Doubtfire. Okay, they get to talk when the jury goes out. It is 4:45 there. I like his hair down like that. I think it looks better down like that than it does in his
Step outside
ponytail.
for just a few minutes? Thank you.
Okay, so let's hear what they got to say.
Okay. So the reason that I asked the jury to step out is that we had, at one point, Mr. McDermott had objected to what he was concerned was going to be a line of questioning by the state regarding this witness's statement as to the results of some sort of DNA. I indicated that for now we were going to stay away from that topic with this witness based on the discussions that we had at the bench. And the reason that we are now revisiting that issue is that Mr. Fawcett approached and asked the court to sort of revisit that ruling. And I felt like we needed to have a more fulsome conversation on the record on that topic so that I could rule. And so that's what we're doing now. Mr. McDermott, you were the one who originally asserted that it would be improper for the expert to for Dr. Terry to make those statements. And you were citing the Williams case, which I found. I think you also cited a Watkins case, which I was not able to locate. I mean, I found, that doesn't mean it, I mean, I just can't find it. I found Disharoon, which obviously where I think Namias is indicating that's an issue that's before the Supreme Court. But
you said Williams, but the case I cited was Smith v. Arizona.
I apologize. I thought you said the Williams case out of the U.S. Supreme Court and the Watkins case out of the Georgia Supreme Court.
Smith v. Arizona out of the U.S. Supreme Court.
That's after Williams and explains Williams.
Thank you. That's the part that shows you why I couldn't find the Watkins case.
Smith v. Arizona is 602 U.S. 799.
602 U.S. 799. And what is the
779?
And what is the Georgia case?
Watkins is 320 Georgia 862.
320 Georgia
862.
Thank you, sir. If you'll give me just a second to pull that up, and then Mr. Fawcett, I was going to call on you to let me know what the state's position is.
If you read Watkins, you can start at 872. Paragraph head to 16. The middle of that paragraph explains it in 2 sentences. Yeah, so, I'm sorry, 320. We're at 862. Looking at around 872.
So can you give me that site again? Because I thought you said 320 Georgia 860, but that's not.
862.
Thank you.
I'm over here talking to myself because, like, I have it muted. You have some response to chat conversations. Floyd baked potato. Oh, Floyd sounds great. I know. I'm I'm hungry. I was sitting here snacking on I made a cucumber and tomato salad with some dill and vinegar. So that's what I've been munching on all morning. And look, meat's over here being good. You having a bacon, lettuce, and tomato. A BLT. Sounds good.
Yes. Your Honor, the state is relying on 24-7703. I think the issue comes down to whether or not the state is intending on introducing documents related to those test results. The experts can rely on evidence, information that is not admitted into evidence, even evidence.
And routinely do, informing their opinions.
That's correct. And so her opinion is based on it's going to be called to determine the cause of death of Ms. Wolfenbarger. And ultimately, she relied on the test results from LabCorp to make that determination as to the cause of death. And that's what her opinion is based on here.
I think maybe part of the reason I'm confused is what exactly is the DNA result that that we're talking about here?
So
is it confirming that this is Melissa Wolfenbarger or that there's some sort of DNA match to her?
Yes, confirm. Well, the DNA match from well, actually, no, it's the swabbing of Norma Patton and the comparison of that to the extremities that were located on June 1999. Confirming that she was related to Norma Patton. Okay,
and is that in dispute?
I didn't think it was.
I mean, forgive me if I fully acknowledge I might be missing something here, but I was not aware that there was a dispute that those body parts were in fact Melissa Wolfenbarger's. Maybe there is.
Well, first of all, it shouldn't matter whether there's a dispute or not. The rule's the rule. They can't testify to this.
Well, except that I don't have to venture into deciding what the rule is and how it applies in this case if it's not relevant evidence. That's why I'm asking the question. But yes.
There are test results in the back and forth discussion over identifying those remains that in some cases they did not match. So I don't think it is a 100% proven conclusion that all of those remains pertain to Melissa Wolfenbarger.
Okay. Well, I guess that demonstrates that I did miss something. There apparently is a dispute that all of those body parts are belong to Melissa Wolfenbarger. And again, asking the obvious, Mr. Fawcett, why would whether those body parts belong to Melissa Wolfenbarger or not be evidence of the fact that that her manner of death was homicide?
I guess I'm not understanding the question.
So I don't understand the DA to be offering, I guess the evidence that you're seeking to offer that this witness would testify about is the fact that she understood from the DNA result that those were Melissa Wolfenbarger's body parts.
Correct, yes.
Some of them anyway, according to Mr. McDermott's characterization of whatever that shows. Why does that contribute to the ME's understanding of whether the death was accidental homicidal, suicidal, or undetermined?
Well, I mean, I think she wouldn't be performing a cause of death determination if the remains weren't first determined to belong to the same person the skull did. And I think the skull's being compared with extremities. And that's a part of that too, because you have the same type of cuts and marks on the bones of the skull as you do for the extremities. I think that's a pretty significant fact in that determination of the cause of death being highly likely of being homicide. So I think that, it wouldn't have been a comparison of extremities with the skull if there hadn't been that information provided by LabCorp to Dr. Terry and Dr. Parker. And ultimately, that's why they made that cause of death determination after all the parts were identified and matched the parts on April 1999, the parts on June 1999. So ultimately, if there's an issue as to a specific part, the Dr. Terry can testify as to which part she swabbed and sent off. So if there's a femur versus another femur or an arm that's in dispute, I think that goes to the weight, not admissibility.
Mr. McDermott, can you, I've got Watkins pulled up and I'm still admittedly struggling to locate the portion that you're directing me to.
Okay.
One part of the case that we were successful in.
Yeah.
Congratulations. I'd love to read it, but I can't find it.
So first of all, that's the state case. There's also the Supreme Court case that it's Watkins is citing. But if you go to 872.
You said, I think you directed me to a head note and I can navigate it more quickly from there.
So head note 16.
Thank you, sir.
And that'll take you to a paragraph that begins with the word second. Second, the trial court clearly and obviously erred.
I have found it now. Thank you very much.
The beginning of that paragraph says to begin the Sixth Amendment's confrontation clause.
She is. And I just dropped the Discord link if anybody's interested. Oh my God, my daughter is so bad. She needs to stop texting me. What is okra? Okra is a vegetable that has little bitty white balls in it. If you boil the okra, it turns slimy. But I love to boil it, put butter on it with lots of salt. Oh my God, it's so good. It's so good. Okra is delicious. I'm just one of those freaks that likes it boiled. Not everybody can eat it boiled because it is slimy. It's kind of like eating an oyster for the first time. You got to know what you're doing.
That's what I'm looking at now.
Well, Smith addresses Rule 703 and its relation to this analysis. If you go well, it's in section 2 under head note 9, but you got to go down to the next paragraph.
Mr. Fossett, have you had a chance to look at the Watkins case or the Arizona case that Mr. McDermott is referring to?
I'm still looking at it, Judge, but we can proceed.
Okay. As I said, when we were at sidebar, Mr. McDermott mentioned the Watkins case, but I couldn't locate it while we were up here. I have now had an opportunity to review it, and it does appear that the Watkins case and the Smith versus Arizona case on which it relies would prohibit that witness from testifying. I understand your effort to distinguish it by saying, well, we're not offering the lab result itself in evidence. And I agree with you that expert witnesses do routinely rely on other people's opinions. But I think that the original ruling I made at sidebar is still the ruling, which is that the DNA test result is hearsay, and there's no one here who can testify to its to the truth of that result, or at least, well, I take that back. There might be, but this witness is not that person.
All right, Your Honor, I would ask for permission to inquire to Dr. Terry whether she collected a sample from Norma Patton, what she did with that sample, and then what she did after the sample returned. I don't think that line of questioning it touches on the results themselves. It just explains her actions and activity, and then what she did after she received information back from that.
Mr. McDermott?
I think the rule covers that type of questioning. I mean, it's clearly designed to elicit through dancing around the issue of the statement the truth of the statement that's in the lab results. And I would say that's just as much a confrontation issue.
Okay. So as I understand it, Dr. Terry did in fact conduct a swab herself. She's certainly allowed to testify about something she undertook. She's also allowed to say that she sent it off for testing because that's something she also did. The extent to which she received a result or anything like that, I agree, invites this sort of cutesy half dodge around the fact that there's not a DNA test result witness currently and that DNA test result's not in evidence. And so just in generally speaking, Mr. Fawcett, the two questions you mentioned at first, I totally agree. Those are fair game. Those are actions that this person took and she can testify about them. I think to some extent, you could probably ask her what her other steps taken were in her investigation that led to her decision. But what you're going to want to be real cautious about is treading too closely to the line that invites her to say, after doing that, did you develop an understanding or whatever? Because Mr. McDermott's concern is correct that it comes too close to creating an inference that's not supported by any evidence in the trial that there was a positive DNA match.
Yes, sir. I understand.
Mr. McDermott, you can object when he asks the question if you have an objection to the particular question. If you find it objectionable in some manner, other than the record that you've already made. Anything else before we have the jury back in?
Nobody's going to speak up? Anybody before we bring the jury back? Of course, they mute the court. We can't hear what they're saying. Yes, Cindy. Yes, you can fry it in the frozen veggies. Yep. Look at this, Norma. Everybody's helping you out, babe. Everybody's helping you out. It's in the frozen vegetable section. And they're breaded. And when I buy them, I put them in the air fryer because I don't like all that grease. So I do put my fried okra in the air fryer, and it's delicious
Mr.
that
McDermott,
way.
anything from the defense?
And yes, you have to salt it immediately.
Okay. Can I have the witness back, please? Thank you.
Yeah, not everybody can eat it boiled, but that was one of the I remember, oh my God, y'all. I remember as a kid, my mom always trying to put us on diets because I was a fat kid, still fat, it is what it is. I got big bones, my doctor said. But yeah, so that was one of the quote diet foods that my mom would feed us.
Thank you.
Was boiled okra because it was healthy. Although, now thinking back, she covered it in butter and salt. So I don't know how healthy that was. Bless her heart. God rest her soul. Now that I think about it, it was so unhealthy. All that butter she put on it. Oh. She would pickled okra. I like pickled okra too. I like pickled okra too. Um, I'm very. we have a gas station in Texas called Buc-ee's. I think it's spread to other states, but they have little jars of different things, and they have a jar of pickled okra that is to die for. It is so good. The pickled okra in there. It's healthy, but not putting a ton of butter on it like my mama did. Although it was good that way. And that is my preferred method of eating that, is with lots of butter. But it's a healthy vegetable. It just depends on how you cook it. Depends on how you cook it. Your back guts? I missed you, Journey, but I didn't miss your guts. Typo queen. Oh, I love Buc-ee's, Cindy. There's 3 of them near my house.
Please be
I
seated.
I love
Mr.
them.
Bissett, you may resume your examination.
Now,
Love your guts, Journey.
Dr. Terry, did you ever meet with Norma Patton?
Yes, I did.
And you recall around what time period that would have been?
I think it was March 19 of 2003.
Okay. And are you familiar with the process of collecting swabs or samples from individuals?
Yes.
And can you tell the jury whether or not you did that at the time you met with Ms. Patton?
Yes, I did.
And are you familiar with collecting samples from other items that you intend to have compared?
Yes.
And did you do that in this case?
Yes.
All right. And in particular, did you swap the extremities of Melissa Wolfenbarger that were located in this case?
No, the extremities were not swabbed.
Okay. What other item, a piece or body part was compared?
I'd actually have to check the record to see, but tissue from the extremities, bone or soft tissue, had been submitted for DNA.
Okay. All right. And is that the process that you use in your identifications for skulls as well as other parts as well?
It can be. Oftentimes with skulls, though, if we have dental, we will use dental to establish an identification rather than DNA.
Okay. I want to turn your attention back to some of the marks and the cutting that we were just testifying to. I'm going to show you State's Exhibit 66. Does that look like a saw to you?
Yes, that is a type of saw.
Okay. You familiar with the term, say, sawzall, or you familiar with that term?
Yes, sawzall or reciprocating saw.
Okay. You familiar with the motion that type of saw makes?
Yes, I am.
You ever used one?
Yes, I have.
And the marks that you were testifying to in the bones of Melissa Wolfenbarger, is this the type of instrument that can make the type of cutting marks that you were testifying to?
It could make that type of mark, yes.
Based on your experience?
Yes, based on my experience.
That's all I have, Judge.
Thank you. Mr. McDermott, questions for this witness?
Yes, ma'am. Not many. Hello, Dr. Terry.
Hello.
You remember me?
Yes, I did.
We met just a couple of weeks ago, I believe it was, or?
Yes, we did.
Okay. And that was at your office?
That is correct.
We discussed several aspects about the case.
Yes, we did.
Okay. What methods, again, did you use to determine the identity of the skull?
The method that was used to determine the identity of the skull was dental.
And did you mention that you did x-rays?
Yes, x-rays were taken, or I had taken x-rays taken in the medical examiner's office.
Okay.
And that was to establish the dental.
And when you establish the identity through methods such as that, is it important to keep records?
Yes, it is.
Okay. And do you normally keep records when you do something like that?
Yes, records are kept in the medical examiner's office.
And did you preserve the x-rays in this case?
The x-rays should be preserved at the medical examiner's office, the Fulton County Medical Examiner's office, yes.
And are you aware that no medical or no x-rays exist in this case currently?
I'm not aware of that, but there have been changes in the regimes over the years. And at that point in time, there was the hard copy x-rays, and we kept those x-rays there. Now, I have not worked in that office since 2004, so I don't know, but they were there at the time I left the office. And now so many things are digital, but those x-rays were there at the time I left the office.
Whose responsibility was it to preserve the x-rays?
It's, like I said, they're there in the office. They were maintained in the office. So I would imagine it'd be the records custodian for the Fulton County Medical Examiner's office.
When you did the dental comparison based on the dental charts, not the x-rays, but the charts, do you remember the x-rays that were given to you to start the comparison?
Yes, there were bite wing.
I'm sorry. I said x-rays. I meant dental charts.
Oh, the dental chart. I have documented in my note that there is one page of dental charts.
Okay. And do you remember where that came from?
It came from Detective Stott, S-T-O-T, from the Henry County Police Department.
And do you remember the dentist?
I do not recall the dentist.
I wouldn't expect you to know his actual name. Do you remember what date that dental record was from?
It was from 1991.
1981. Melissa would have been 13 years old at that time.
I do not recall her date of birth.
Okay. If well, do you remember observing the remains of the head? You said the first time you saw it was when?
February of 2000.
Okay.
When I was turning them over to have a reconstruction done.
So you never saw it when it was not a skull?
That is correct. I just saw pictures.
Okay, so you've only seen pictures.
Up until that point, yes.
And in those pictures, you could tell that it's badly decomposed?
Yes.
And you mentioned that there were no flies on it, so that was probably a recent.
Right, that it had recently been exposed. I didn't see any fly eggs. I didn't see any fly eggs described on it. I did not see any maggots or maggots described as being associated with these remains, even though they were described as being badly decomposed.
Okay. And you remember that the other remains are in similar condition?
That is correct.
And they had been in these bags?
Correct, with the exception of the one that was out at the time of the discovery, but a bag was nearby.
And Mr. Fawcett discussed with you the concept of PMI, post-mortem interval, is that correct?
Correct, that is what
And
PMI stands
that's
for.
a fancy medical examiner way of saying how long ago did this die?
Correct.
Do you remember me asking you questions about PMI when we met?
I do.
And do you remember me asking you, based on the pictures of the skull and the remains that we saw, if that could have happened in a relatively short time?
I do remember you asking that, yes.
Okay. And do you remember answering yes?
Yes, that is a possibility, yes.
Okay. Do you remember me asking you specifically, would it have been conceivable to have gotten in that condition within 30 days?
I do remember you asking that, yes.
And your answer was, yeah.
Yes, that's possible, yes.
Well, you didn't say just that's possible.
Oh, okay, well.
You said enthusiastically, yeah.
Well, I mean, again, it's possible. I wasn't having the conversation transcribed. You were recording it, but yes, it is possible. But there are a lot of variability or variables that go into how quickly something decomposes.
Okay. And we discussed those when we met, right? That they were in bags.
Yes, we did.
Those bags could have been exposed to sunlight.
Yes, the temperature, yes.
Temperature is very important to decomposition.
It is very important to do.
And something in a black plastic bag in the sun would be warmer inside the bag than outside.
That is correct.
Okay.
I think I also mentioned we don't know where the plastic bags have been, too. They could be stored somewhere.
It's fair to say, I'm sorry, did I stop your answer?
Oh, no, I was just going to say, there's just so many variables. It's difficult to say.
Yeah, that's my point to ask. When you normally do postmortem interval on remains that are found, it's usually an intact person.
That is correct.
And all those variables, you can calculate to some accuracy how long it's been.
Yes, some of those, we can, we have some knowledge of, yes.
But when a body has been dismembered, as in this case,
Dismembered, placed in plastic bags, potentially concealed.
pretty much all that calculation goes out the window.
Correct. There are just too many variables there to say what the postmortem interval is.
And I think you said to me, so it's like, could you say it's been days or weeks? Probably something like that.
Correct.
Okay.
It could be days, weeks, months. Yes.
Thanks. All the questions I have, Your Honor.
Thank you, Mr. Fawcett. Any additional questions for this witness?
Now, you were talking about the different variables. Can you say, based off of the information you have, the photographs and the circumstances, that the remains were found when Melissa Wolfenbarger died? Can you say that?
I'm sorry, can I say?
Can you estimate a time of death?
Oh, no, I cannot estimate a time of death, no.
And in terms of the variables that you were speaking with, would say the tying up of the remains in a bag and dropping them off at that location, can you say that they weren't there or that she didn't die in December, for instance, of 98? Can you say that?
No, I cannot.
And what type of variables prevent you from making that determination?
Again, she's been dismembered, placed in plastic bags. I don't know where these bags have been stored or for how long they've been at the location where they were when they were discovered. Just because they were discovered there doesn't mean that they've been stored there for a period of time. I don't know where they've been between the time of her death and when they're discovered. And I don't know when the time of her death actually occurred. So I don't know.
Okay, that's all I have, Judge.
Thank you, Mr. McDermott. Anything else?
Nothing further from the witness.
Thank you so much, Doctor. You may step down.
Thank you, Your Honor.
Counsel, can y'all approach?
Female journey. Her name was Carol Terry. His hair looked shorter like this out of a ponytail. To me, it just looked longer in a ponytail. Sorry, I was trying to update the server while I was listening. Doing new things in the background, learning. Because I don't know
how to whisper. And I'm including myself in that statement. Thank you, ladies and gentlemen. So it is about 5:15. We are going to adjourn for the day. I'm going to direct you a couple things just as I have each day. One, I need you to return tomorrow morning at 10:30. Tomorrow morning again, 10:30 a.m. We will begin then. And then I will just advise you, as I have each day, that your decision in this case is supposed to be made only based on the evidence that you hear in this case, in this courtroom, and not based on anything else. So
I'm going to cover that real quick. A cold case solved real quick. It's just going to be like 5 or 10 minutes. And then you think so? Yeah. Anyway, I'm going to cover this cold case real quick. It's going to be like 5 or 10 minutes. And then we're going to go for the evening. Unless I find something else to throw on. I might come back in a little bit. I need to go walk the dogs and feed them and all that. What in the world? These dogs, look. And now I got a sock. See? They're dogs. Flat iron. I want to see if they say anything else after the jury leaves. Right? I would have to use a flat. I mean, let me tell y'all, because with my hand's getting better. It's getting better. It's healing. It's still got a little cut there, but it's healing. And I was having trouble for the first 2 days of having to brush my hair and be able to pull it up. So that's why I was just wearing my little bun thing going on, because it's really hard to brush my hair.
Okay. Jury's clear. You may be seated.
Okay. Let's see what
any specific issues the parties want to take up before we move on to something else. So you'll remember I sent y'all the jury charges. I did want to have, I mean, I don't plan to have a full entire charge conference right now. But given that I expect that the state will probably be wrapping up its case first thing tomorrow, and that we either will or won't hear, depending on what the defense decides to do, I think it makes sense for us to at least have a first pass. Have the parties had a chance to look at the jury charges that I sent, and any specific matters y'all want to address in terms of concerns you have. Yes, sir, Mr. Samuel.
Yes, I've looked at them.
Okay.
You want to go specific?
Any from the state? Who's going to be handling that for the state? Like, I'm sure all of you, but which one of you is going to talk about it?
I haven't looked at them yet, Your Honor.
Okay. Well, I tell you what, let me make it easier so you're not. That's why I asked you to look at them. So let me put them on the screen, and I think that will help, because it will also let you understand how they will be displayed to the jury when I do the charge. So anyway, the second charge is just a general pattern charge. I mean, it's not a pattern charge. It's just a general charge of, hey, the law
is what I say it is and not what the lawyers say it is. And then beyond that, other than typographical errors, all of these are pattern charges. The only issue is
I don't know what happened.
to this evidence in this case.
This says the defendant has no burden of proof at all. The burden never shifts to the defendant to prove his innocence. When a defense is raised by the evidence, the burden is on the state to negate or disprove it beyond reasonable doubt. However, the state is not required to prove the guilt of the defendant beyond doubt or to a mathematical certainty. Reasonable doubt means just what it says. It's a doubt of fair-minded, impartial, who is honestly seeking the truth. It is a doubt based on common. Okay.
It's such that you shouldn't be given or need to be tailored further.
Lola is 5 months.
I can give you a list of my issues. 131.42, witness supported. I'm not sure we had that.
Yeah, so again, I exercised no editorial control over this. I simply put on here what you guys had listed. So not only have we not had that, but generally speaking, attacking a witness and under 131.41 is a very specific process that sometimes may or may not have happened either. I agree with you. We certainly have not had any witness supported. I'm not even sure we've had witness attacked, except perhaps by, that one needs to be tailored because perhaps by prior convictions.
Yeah, and then
hang on. What are your thoughts in terms of witness supported, Ms. Hilton, the conversation we were just having?
Yes, Your Honor, we agree.
I mean, I haven't heard anyone be rehabilitated in that manner.
Correct. We will withdraw 131.
Okay. And to be honest, I don't know that anybody actually asked for that one. It's one of those, they go together. And if we have witness attacked in that particular way, then I'm going to keep witness supported in that way, unless somebody agrees it shouldn't be. Mr. Samuel?
I made a note of 131.80 in case anybody was wondering what we were referring to. I was referring to the immunity of Norman Patton.
Right. You made that note in, did you have a chance to file? I know you gave them to me, and at the time you gave it to me, you said you had not yet filed the jury charge request.
I served it. No, I didn't. I don't know how to file.
Well, somebody in your office certainly does, Mr. Samuel. So
yes, someone could do it. Yes.
Okay.
But everybody's got it. You know what to do about 404B and all the 1.3410. I'm perplexed. I'm beginning to think you're just not going to give any 404B instruction at all because there was no similar transaction evidence in this case.
That is I think you're beginning to suspect correctly.
Yeah.
As I was looking at it, I had always wondered because I'd not heard what I would clearly categorize as 404B. I understand your objection and your belief that that these prior alleged, the testimony that the state has offered about prior incidents that they would characterize as abusive in support of Dr. James or Ms. James's testimony. I believe, as I said at sidebar and then said again when I declined to give a limiting instruction, I believe that those are intrinsic and that intrinsic evidence is allowable, the jury can consider it for any purpose, and so there's no basis for a limiting instruction.
Right. To be candid, I can't even figure out what the limiting instruction would be, which is kind of my whole issue is what was it? But unless we accept your position that it's just all part of the crime, I'm not sure what the 404B instruction would even be, which is why I thought the evidence should be excluded. But we know where we've been on that.
Sure, yeah, and I think you have, I think I have, after I had that discussion with y'all at sidebar, I think I actually went in and deleted those limiting instructions and the associated other crimes, wrongs, and acts instructions.
I don't want to waive my issues, but I certainly understand that they're not appropriate if in fact they weren't admitted as similar transactions. Okay.
Yes, sir.
I think prior difficulties, 13420 still stays in.
Any objection?
No objection to 13420.
It needs some editing, but
Well, yeah, I mean, if there are parentheticals still in there, that means I haven't tailored them yet, but I'm not going to waste time tailoring stuff if everybody says, no, we don't need it, so.
Right.
Can we go back to 13180, the immunity or leniency?
Yes.
Your Honor, they would object to that being given. While Ms. Patton did discuss the immunity she received, that was as related to her trial with Mr.
Patton.
Mr. Carl Patton. Is not anything doing with this current case. She hasn't been given immunity. She hasn't been charged with anything in this particular case or matter before this jury. There's no pending prosecution before this jury. There's no negotiated pleas. She wasn't a co-defendant in this case, so there's no grants of immunity or leniency or similar matters as it relates to this case. So we would object to 13180.
Mr. Samuel?
Usually I do charges sitting down, but I'll stand up.
That's fine. You're not bothering me.
Once you're given immunity, you're given immunity. It carries forward, all the federal cases and all of which are, the names of which are escape me now, but the New York case. Anyways, the U.S. Supreme Court said once you're granted immunity, it's good for life on that grant of immunity. So theoretically, which is all that really matters for this, she could still be prosecuted, and because the statute of limitations hasn't run, because it never does in a murder case, she could be prosecuted in theory in whatever it is, Henry County, Fayette County, wherever. And so having testified here, because she was immunized, she doesn't have to worry about that. If she hadn't been immunized and she got on the stand here today, yesterday, whatever day it was, and said, yes, I participated in the murder of some of the people my husband killed, she could be prosecuted for it, but she can't because she's immunized.
So my concern is not quite, I think right now I sort of agree with Mr. Samuel, but not for the reason that he's outlining. It's more that my understanding of the law around it and the pattern charge certainly is that it's not specific, right? It doesn't say they were granted immunity in this case. And so if it's intended to be, because the factors we take into consideration when we're assessing the credibility of a witness are pretty broad. These are just examples that we give a jury in terms of things they can consider. If the state wants me to think about not giving that charge based on Mr. Samuel's request that I give it, I would say, see if there's case law that talks about it being specifically designed for immunity in a case, as you outlined correctly, Ms. Hilton, that Ms. Patton was never in any jeopardy associated with this case, and I'll consider that tomorrow.
The case is Murphy versus Waterfront Commission of New York Harbor, 378 U.S. 52.
378 U.S. 52.
Yeah, and there's a long discussion of it in a Supreme Court case decided 6 weeks ago, Coleman versus the state.
K or C?
With a C, S25 AO191. Different circumstances, but it talks about how broad immunity really is. Once you've been given it, you're protected for life in every court of that testimony.
Okay. And as I said, that may go directly to my point that this pattern charge is not specific about this case. It's just about immunity generally. And if that's the case, then I will give it based on your request, but I would like some more information about that topic. So I'll take a look at this case and hear from the state tomorrow on that issue.
Your Honor, before you go, I'd just like to cite a case from Georgia, Lee versus State, 281 GA 776. And I believe the proposition is that the general credibility instruction adequately covers that.
Adequately covers the other immunity?
The other instruction.
Okay.
I need to drill down on it exactly, but that's what it's saying in the notes on the jury charges.
Okay.
So I'm going to look at it as well. I just want to give that to the court.
Thank you. I appreciate that, Mr. Wilson. Okay. Anything else, Mr. Samuel?
Yeah, a few more, but they're not big. 13430. It really just needs to get rid of all the parentheses for the defendant. No felonies of Mr. Wolfenbarger's work, but all the witnesses.
Yeah, the reason that's why I haven't tailored it because
At first I crossed it out, but then I realized, wait a second.
Yeah, there's lots of witnesses we've heard felony convictions about. And so if evidence comes in about felony convictions of the defendant, right, then I'm not saying it has, I'm saying if it does, then I would tailor it to be, you've heard evidence about both the defendant and a witness's criminal history. But if it's just witnesses, I'll say that.
Right. I'm a little in doubt about 13510 identification. The first page of it, I think is fine. You got to prove that the defendant did it. That have identified him as being, but this is
all about whether you can trust eyewitness identification, et cetera.
Which we really didn't. I mean, it's not an issue in this case. We don't have any eyewitnesses identifying anything. So I just thought we should get rid of that and 13511, those two pages, but leave the first one because that just says someone's got to identify the defendant as the perpetrator. It doesn't necessarily have to be in court, but
Right, I believe we may agree, but if I could just have a moment.
Sure.
Tonight to.
That's fine.
Get it, but
Yeah.
we may be in agreement about that.
Okay, let me know. Like I said, I think to Mr. Samuel's point that second part, the some but not all of the factors, if you read those factors, they really do go to a stranger's identification based on eyewitness observation. And that's not really what this case is about. I'm not sure I necessarily agree with your assessment of 13511, that would be more directly here in terms of the state's obligation to identify a defendant, but we'll go, I'll let the state have a chance to look at that and consider it and tell me tomorrow.
I crossed out my crossing out.
Okay.
That was in, still in.
Okay. Anything else, Mr. Samuel?
Got 2, 3 more.
Sure.
I'm not sure about the motive instruction. I think they have to have evidence introduced of the motive. I know motive is in the malice murder instruction already. That motive is not an element, but may help you decide. But I don't feel strong. I know it's a pattern instruction. I just don't know that there's evidence of motive that's been introduced exactly. It seems like,
except that the pattern says they don't have to prove motive to prove murder, and it also says any evidence of motive. If you want to argue there isn't any evidence of motive that's been offered, you can argue that, and they'll say, but yes, there has been. It doesn't matter. As I understand it, that one is written broadly enough that both sides can argue, here's our evidence of motive, even though we don't have to give it to you. And you can argue there isn't any.
there was I got a typo in causation in felony murder 21030.
Yes, sir.
But 22023.1, which was ours, I'm not quite sure what to do about that.
I'm sorry, what is the typo?
20.23.1.
No, I'm sorry. What was the typo in the causation charge?
It says felony murder if you believe that they instead of he.
Ah, thank you.
Yep. 2.20.23.1. I just don't know how we're going to address this, but we need to probably think about it. Everybody needs to think about how we're going to talk about the aggravated assault that makes it aggravated.
Yeah, I full disclosure, when I was drafting these charges, realized that I've tried a number of felony murder cases. I've actually not tried a felony murder case before this one where the underlying felony wasn't also charged. I don't know, as my understanding is, it's not required to be, but I've just not had one where it wasn't also charged.
Well, they actually didn't even request ag assault in their pattern.
I understand.
Which Joel and I spent a lot of time thinking about why they didn't do that. But at any rate, we did. But now the question is, how do you do it?
Well, I think we all obviously need to have a more detailed conversation about it tomorrow after everybody's had a chance to look at it. But the aggravated assault charge I think is less confusing. The issue is deadly or offensive. I don't think that I can meaningfully charge the jury on felony murder if I don't tell them, but the felony is based on an underlying alleged aggravated assault. So I think I have to tell the jury, as felony murder says, the underlying felony that's alleged is whatever, and I will define it for you shortly. So I have to tell them what aggravated assault means, but that typically requires the court to explain what type of weapon did it, because that's one of the elements, is that you assaulted another person with an offensive weapon, and then you have to explain what was offensive about it.
Murder, felony murder.
And just to anticipate what we may be talking about tomorrow, it can't be strangulation because that's a separate crime, which is not alleged.
Is the aggravated assault
It's only offensive weapon, not
charged as an offensive weapon in the indictment?
Yes.
Okay.
What indictment?
Okay. Anything else?
Nothing. That's all I had on my list.
Okay. I'll just note, in case y'all didn't, it sounds like you would have looked at it, but I do another one that is non-pattern that I typically include. I cannot believe there's not a pattern on multi-count indictments. But this is the one that a lot of us use, and so I include it. You'll also probably note that my charge is sort of in the order of, this is how you consider evidence, and this is, what's been presented to you and how you should think about it. Here are the elements of the crime that you're supposed to be determining if you believe occurred, and then here's how you deliberate. That's sort of the way it's broken up, and so you'll note it's not in number order, but that's sort of how I present it. And also, I sent y'all a verdict form the other day. It's pretty straightforward. It just says we find the defendant guilty or not guilty on count 1, guilty or not guilty on count 2. Any objections to that verdict form?
None from the state.
Nothing from the defense.
Okay. So I think it sounds like what I'll do is I will tailor some of the ones that it seems like we're in agreement are going to stay in based on the evidence as it currently exists. Obviously, they can be tailored again, depending on, I sometimes will tailor the defendant's choice not to testify, depending on whether he testifies or not. Although I think the pattern is written generically enough that it can stay in either way. And then obviously, depending on any additional evidence
Do y'all
that
think
comes
he'll
forward from
testify?
history, I can tailor those. Beyond that,
I hadn't even
what I'll
thought
do is
that
wait
far.
until tomorrow, specifically so we can talk about the aggravated assault and offensive weapon charge, what we're going to do with that. And then the other ones, the other few that we've discussed.
Can you ask
The
about
immunity charge, yes, sir.
tomorrow? I'm sorry. Can you ask us about tomorrow's schedule? It's 10:30 because you have something else we need to clean up. Do you have another calendar?
Yes, I have the presiding bond calendar tomorrow morning.
So we need to clear out.
Yes, sir.
Okay.
I'm sorry.
We'll put everything in the back. And assuming our case takes
You don't think
a couple
so?
hours, I don't know if they have rebuttals.
I don't think he will either.
Going into closing argument tomorrow, or ready to Friday morning for that?
What?
If what were to happen is that the state were to stand.
Wait, what did he say? Closing arguments.
Rebuttals. Do you envision going into closing argument tomorrow, or ready to Friday morning for that?
If what were to happen is that the state were to stand up and rest in the morning, and then you put on a case that is relatively straightforward and short, even assuming rebuttal, the state, we probably would be done still in the afternoon. I'm saying pushing 3:00 is my guess, at which point I'd rather get a final on the charge and start fresh on Friday morning we all agree that we've got the charge final. And so you guys get ready to do your closing, and then I think that time would be better spent tomorrow afternoon. So no, that's a very long way of answering your question, Mr. Samuel. No, I do not expect to go into closing arguments tomorrow afternoon. Anything else?
No, Your Honor, nothing to mistake.
May I have just a second, please?
Yes, sir.
So if the state rests tomorrow, the defense doesn't have a very big case to put on. Obviously, if he's talking
My
about
witnesses, that we expected we may possibly be testifying today, so I had all my witnesses come.
Yes, sir.
And one of them was supposed to come, didn't come.
Okay.
And I think she's a little bit of an adverse witness.
Yes, sir.
So I'm wondering if we could make arrangements possibly for tomorrow to have a deputy pick her up.
Is it someone, I mean, I don't have any objection to that. What are the states? Are y'all aware of who this is?
When do you want that?
I'm so sorry, Your Honor. We were talking about the aggravated assault.
That's okay. Mr. McDermott was saying he had a witness that was supposed to be here today who did not appear, and he thought that she might be somewhat reluctant or adverse. And he was requesting the court to see about having a deputy assist her in appearing tomorrow.
Oh. No objection from the state?
If you have an order.
I will, well, I was gonna say, if I could touch base with you in the morning.
Sure.
I'll talk to her, get the
Okay. The only thing I'll ask is if you do want me to do that, you need to have a proposed order ready for me to sign. I may need to change it, so you can just email it to me in Word format. But that way I have something done and you don't have to wait for me to write an order. So, okay.
Staff have a form order for that, or I can make one?
They probably do, but I don't have one at the ready. So,
All right.
Anything else from the defense?
Nothing from the defense.
Okay. We are adjourned until tomorrow morning at 10:30.
Okay, wow. So that went a little spicy in there. So somebody they told to come to court did not show up today. And so now they want to have a deputy pick them up. Wow. Okay, so I just want to play this. This is it's only a minute and a half long. Hang on, let me find I had the article pulled up. I have so many windows open though. I'm sorry. Give me just a second. I need to find. Here it is. Okay. So there was a house fire on October 19, 2013 on North Randolph Avenue in Clarksville, Indiana. And they discovered two men. One was Armando Miguel Rodriguez Solis and Julio Cesar Ventura Mazon. They were stabbed to death inside the house. But there was a fire that was set to the house, and it was later determined to be arson after they did all the investigation and stuff. And they found that the two men inside the house had been stabbed to death. So, and then there has been a suspect in the murders. His name is Carlos Alberto Bonilla. He was 46. He was arrested in Georgia, and DNA evidence is what was able to link him to this crime. So let's watch this real quick. And
our top story takes us from southern Indiana down to Georgia. The person suspected in a double murder in Clarksville from nearly 12 years ago was just found at an ICE facility in Georgia. And we found out his name is Carlos Alberto Bonilla. Now, police said on October 9th of 2013, officers responded to a house fire in the 400 block of North Randolph Avenue, where two men were found stabbed to death inside that home. Investigators collected DNA samples at that scene and searched for a third man who was a resident of the house but never found. That was until last month when Bonilla, a Salvadorian national, was arrested and held at a federal ICE facility in Georgia. His name was flagged upon his arrest, and Clarksville police were notified.
Throughout that investigation, it was determined that both of those individuals had been stabbed to death. So one individual had stab wounds on over 90% of his body, and the other individual had
90 and 95% of their body stab wounds. Y'all, think about that. Oh, my stars. That's just insane. That is a lot of work this man put behind these stabbings.
Stab wounds on over 95% of his total body surface. So I think it would be prudent to say that this was a brutal double murder.
The suspect again in Georgia, now awaiting extradition to Indiana.
So, and with that, yeah, and they, hang on, where did I put that chat? Where did I put that chat? Anyways, the reports of a house fire on 436 North Randolph confirmed that the fire occurred on October 9th in 2013, not October 19th. The fire resulted in the death of two men, and they were both stabbed before the fire was set, and they later determined to be arson. So it was DNA that actually linked him to it. So yes, it had to be like every part of the body. I mean, he had to have been angry. I mean, 90% and 95% on the other one. I mean, that's a lot. Oh, here, wait, I have one more. And this is just, I'm going to have to read through it. This is something, this was put out August 19th. So this was yesterday. And this is San Francisco 2015 cold case, double homicide, solved with arrest of suspect. More than 10 years after two people were shot dead in separate incidents in San Francisco, police announced Tuesday an arrest on the cold case. The shooting happened on January 27, 2015 in the city Bayview 100 Point neighborhood. Maria Lord Souza, 32, was hit by a stray bullet in front of her three children outside her home at Revere Avenue and Ingle Street during a rolling gun battle between two vehicles. She later died at a hospital. And this is her. She's so pretty. So pretty. Minutes after the first shooting, a woman covered in blood entered the Old Clam House restaurant on Bayshore Boulevard, less than 2 miles northwest of the first shooting scene. Woman had also been shot and was seeking help. A man who was in her vehicle had also been shot multiple times. The man, identified as 38-year-old Dante Glenn of San Francisco, did not survive. So this is kind of the scene. Two San Francisco police departments said multiple witnesses saw two cars with occupants shooting at each other. Months later, police released surveillance video of a black pickup, possibly a Dodge Ram, to generate leads. On a press release on Tuesday, police said that August 2024, homicide cold case investigators took over the case and eventually developed probable cause to believe 34-year-old Anthony Tyree was responsible for the murder of both victims. August 13th of this year, an investigator obtained an arrest warrant for Tyree. On Monday, approximately 3 a.m., detectives, along with the assistant SWAT officers, served a search warrant at Tyree's home in Pittsburgh. Officers arrested Tyree and seized an AR-15 short-barreled ghost gun rifle he had in his home, which ghost guns we know are the ones that they are making that have no serial number on them. In a press statement, DA's office said Tyree was a passenger in a Dodge pickup when he and another passenger opened fire on Black Infinity. Bullets hit and wounded the driver of the Infinity and hit and killed passenger Glenn. With stray bullet hit Sosa standing outside her home. Tyree's charged in 2 counts of murder with a special allegation of intentionally using firearm, committing a drive-by murder, also charged with attempted murder and being a felon in possession of a firearm. So another cold case solved. And I just find this amazing when they solve these cold cases. And this was one more, and I can't figure out how to get rid of all the ads. But this is, this one was a Minnesota fisherman. They, 2 men were out fishing, and they found a car in a river that was from a 1967 cold case. This is the guys out on a fishing boat. Pair of fishermen stumbled upon a sunken vehicle on the Mississippi River in Minnesota and may have inadvertently helped solve a missing person cold case. So just to show, oh, wait. Let's go back. Brody Lotch and James Ham The two fishermen found a submerged car with a sonar device they were using to locate fish over the August 9th weekend that pinged something unusual after their lucky catch. It was 100% luck. If my buddy wouldn't have caught that walleye, we would have just kept floating down the river and never found it. So the recovery took several hours. They brought in tow trucks and stuff. And this was the missing persons bulletin of the gentleman that was missing at the time. His name was Roy George Benn. Date of birth, April 29th, 1908. 1908. He was 5'8". He was last seen or contacted on September 5th, 1967. Roy Bean was last seen driving his 1963 four-door metallic blue Buick Elantra with Minnesota license plate, also missing. He is reported to have been carrying a large sum of money when he was last seen. So with all that, these gentlemen that were out just fishing, comes across a vehicle in the water. It doesn't say exactly. It says, it's going back, it says, looking back at some of the original case files, there was a talk of quarries. There was a lot of talk of the Mississippi River. At the time of the disappearance, Ben was a businessman and owner of St. Cloud Appliance Repair Service. His wife had died the year before, according to archives. So, and he was declared legally deceased in 1975. So I just found that completely interesting that all those years later, you know, I mean, you just never know. He may have drove off the road. I mean, I don't know. They haven't come out with specifics. Like I said, this was just posted, I think, yesterday. So yes, the car guys, adventure with the purpose or something like that. Totally interesting. Totally interesting. All right. With that, guys, I'm going to go. I may be back in a little while. I'm going to go walk the dogs. I don't know. Let me see. Yeah, a lot of cold cases are in the lakes. I mean, you know, that's the cars. That's where they're finding them. Your grandma was born in 1903. She lived, oh, wow. I know. My mother-in-law, bless her heart, she was born in 1938. She is 86, I believe. And, you know, it's amazing things she talk about. You know, it's just amazing hearing history. I love it. But anyways, okay, guys, with that, I'm going to go. We will see y'all later. Lois, Evamos, Cindy, Journey, everybody. Case One, thank you all for being here. TCN, y'all are awesome. I always appreciate y'all being here. If you don't mind, if you haven't hit the like button, hit it on your way out. And till next time, peace. Forever out. Y'all have a great.
Life's a ride.